Hi, everybody. Thank you so much for being here today. We really appreciate everyone taking this Friday afternoon to learn about a really important and current area of the law. I'm Anna Christensen. I'm the Morgan Lewis liaison with HIAS Pennsylvania and Nationality Service Center. And today we're lucky to have with us Idella Gonzalo of HIAS. She's a senior staff attorney there, and Jonah Eaton, a staff attorney at Nationality Service Center. So they'll be speaking for some time about substantive asylum law. After that, we'll have a few other presenters giving their perspectives on the asylum system, and I think probably have some time for questions. So enjoy. Thanks very much. Before we begin, I would encourage you to ask the questions in a moment.
Yeah, just because we're at a podium, do not be shy about interrupting. Good afternoon, everyone. Yeah, my name is Jonah Eaton. I'm a staff attorney at Nationality Service Center, and asylum and refugee law is the reason I went to law school. It's been my sort of legal specialty ever since. So I'm going to sort of start off with kind of the 10 miles up sort of overview of this branch of law and kind of where it comes from. And then, of course, we'll spend the rest of the afternoon kind of digging in a little bit deeper to the various aspects of this legal regime. So the sources of asylum and refugee law are originally come out of international agreements and instruments. The brief history of this topic is, the world sort of so completely horrified itself at, the bloodshed and the carnage of the Second World War that it led to, the creation of the new United Nations. It led to the sort of codification of various international instruments to try to nail down, a common consensus about what human rights was, and sort of what rules, the international community would bind itself to. So the sort of document for all that is the 48, the International Declaration of Human Rights, which, in some ways was sort of modeled almost on our own Bill of Rights, and the Declaration of the Rights of Man out of France, and various other sort of older instruments from the late Enlightenment. And shortly following that was the 51 Convention on the status of refugees, which really provided sort of a concrete legal mechanism for the vindication of international human rights. Just a little bit of history. So the 51 Convention was sort of actually particularly designed for its time and place, in that it was largely a response to an ongoing refugee crisis in Europe, because of course the war was over, but there were still many millions of people sort of scattered throughout the continent as a result of the fighting, who had been displaced, who had been driven from their homes for all sorts of reasons. And so the 51 Convention was sort of aimed at that, and it contained a definition of a refugee, and then a series of articles following, sort of talking about how one should treat a refugee. But that definition, by a couple decades after, it was slightly obsolete, because of course refugees continue to be a problem and continue to be something that sort of haunts the world's consciousness today. And in 1967, there was the optional protocol to the convention. And so the protocol expanded, internationalized the convention, critically for the purposes of U.S. law, in sort of typical U.S. fashion. While we were there for the negotiation of the 51 Convention, the Senate then decided not to ratify the convention. However, we later did sign on to the 67 Protocol, and the protocol sort of binds you to all the substantive parts of the convention. So it's through our ascension to the protocol that we're sort of bound by the underlying corpus of international refugee law. And then, of course, the stuff needs to be sort of incorporated into our domestic legal codes. And this was a process that also actually took, over 2 decades. There was the 1980 Refugee Act is what, probably really brought U.S. law into conformity with the standards that have been set out by the 51 Convention and 67 Protocol. So the statutory basis of all of this stuff is now contained in the Immigration and Nationality Act, which is Title 8 of the United States Code. Quick practice tip, if you're in immigration court or the asylum office, you usually cite to the INA. Circuit courts, district courts, you're hardly ever going to be in a district court, but you cite the U.S. Code. And then, of course, the implementing regulations at Title 8 of the Code of Federal Regulations. And then, because this stuff is complicated and there's, some ambiguity in parts of the definition, there is a very broad, sort of body of case law dealing with the various aspects of the refugee definition. And most of that, of course, is circuit court case law. So this is a sort of a graphic that shows an overview of how refugees get into the United States. And this is also an opportunity for me to, kind of point out an important definitional distinction between an asylee and a refugee. So you can see, so the convention establishes this international definition of a refugee, and that, you can find that definition all over the place. It's, as I said before, it's in the U.S. Code, it's in the INA, it's in the Qualification Directive of the European Union, which is directly binding on all 28 member states, possibly soon down to 27 if the Brexit happens. It's in the immigration codes of Japan, of North Korea. So this definition really exists all over the world. But the actual process of how, the people who meet this definition and how they get recognized as meeting that definition, of course, there's a lot of variety there. So sort of the first kind of track we have up here is the refugee resettlement process. It's been in the news a lot lately this last year, and that's maybe something we can talk a little bit more later in Q&A if people are particularly interested. But basically, that is a process by which the United States government, since the 1980 Refugee Act, has voluntarily repatriated groups of refugees who are stuck overseas in refugee camps. Because as an aside, the vast majority of people who flee conflict, who flee human rights abuses, end up in neighboring countries. They don't end up in Europe, they don't end up in the US. Syrians mostly end up in Turkey and Jordan and Lebanon. So the refugee resettlement process is a way to try to address these long-term encampments of refugees. And it's a process by which people are identified, usually by UNHCR, the UN agency in charge of refugees, and then they get referred to our government, and then through a multi-year vetting process, certain families are selected and resettled here in the United States. And of course, that is probably the primary function of what NSC and HIAS both do, is we are refugee resettlement agencies, is taking people in from abroad and resettling them here in the United States. There's also the Affirmative Asylum process, and that refers to folks who have gotten here to the U.S. on their own steam. Maybe they managed to get a visa and just, get on an airplane like, anybody else and get to the U.S. that way. This can, they've fled asylum. I'm now on track B, obviously, and then they're allowed to make an affirmative asylum application here in the United States, which is basically just asking the U.S. government to recognize them as meeting the refugee definition and then grant them asylum status. And then you also have, sort of a theme on that is sort of the C track here. People will show up at the U.S. border and request, refugee protection at the border. And there's also a defensive asylum process. So maybe someone who has been here for several years, however they entered, they get caught by immigration authorities and put in removal proceedings, and then they, raise their potential status as a refugee as a defense against deportation. So that's just the overview. Obviously, we'll be talking in more detail about a lot of this stuff as the afternoon unfolds. I said that, as I said at the top, the 51 Convention, created a definition, which is in the definition section of the INA, right up front, 101. And it's any person who's outside of their country of nationality, or is outside of any country when they last habitually resided. So this is known as sort of the alienage requirement. You have to cross an international border to be a refugee. You can't still be in your home country. If you're in your home country and you're displaced, you're categorized as an internally displaced person. But that does much less for you under, international law than actually having crossed that border, and then you might be able to be considered a refugee. You are unable and unwilling to return, unable or unwilling to avail himself or herself of the protection of that country because of persecution or a well-founded fear of persecution. So, I help teach the refugee law course at Penn Law, and that's literally, this is the entire course, is we just go through this definition sort of element by element and, try to expand on it. And indeed, that's what we're going to be doing this afternoon as well. But so the basic requirements are you cross that border, you're unable or unwilling to go back because you're afraid, and you have a good reason for being afraid. And because there has to be a particular reason that sort of motivates your fear, or maybe more specifically, that motivates your persecutor. And that speaks to, the grounds, the on account of, one of the 5 grounds of asylum. So to give an example, if you are, living in a village and a civil war sweeps through your part of the country, and you very sensibly remove your, get out of the way of it and run away, that doesn't mean you may be sort of a refugee in kind of the dictionary or popular definition, but that may not actually get you to the legal definition of a refugee, because your persecution, the harm you fear, has to be, motivated by one of these grounds. So there's sort of a mens rea requirement for your persecutor. Sorry, I'm just catching up with my notes here so I don't blow past where I'm supposed to talk about. And finally, there's the idea that the fear must be well-founded. So, there has to be a good reason for this fear of persecution. So that is the roadmap of what we're going to be talking about this afternoon. And now I'm going to turn the mic over to Aya. And turn my mic off. Let's see. There we go.
Okay, so Jonah has provided the roadmap, and I'm not sure, are you using this?
Yeah, that's a little.
Okay, all right. So we're going to first of all look at the, what does persecution mean? What are we looking at in terms of having to establish to determine whether or not someone has been persecuted and may be eligible for asylum protection? As you can see, there's no statutory definition of persecution. And actually, that's a good thing, right? That's what we as advocates consider. It's a good thing because once you have a definition, then it's kind of set in stone. Anything that is outside of that definition will not be considered as persecution. So we have guidance in terms of what things we have to look at in order to determine whether or not the action that is involved should be considered to be persecution. And the guidance that we have is from the seminal case of Matter of Acosta, excuse me, which is a 1985 case, which essentially says that we have to show that there is a threat to life or freedom or the infliction of suffering or harm upon those who differ in a way regarded as offensive. So that's our general guideline, right? That's what we're looking for in order to determine whether or not the actions that are involved should be considered persecutory. And we also have other types of guidance through case law. So we've been told through case law that substantial economic deprivation can constitute a threat to life or freedom, rape or sexual assault, FGM, which was recognized back in 1985. I think that was the case Kasinga. Confinement and physical torture, arbitrary interference with private or family life, and that, you might be wondering, well, what does that mean? So one of the cases where that was discussed was when China had the one-child policy, for instance. Now it's the two-child policy. I have not done any cases based on the two-child policy, but have you?
I have.
Yeah, and did you win?
Unclear.
That gives you the sense, and also it's about we can use such situations as homosexual private life, which in some countries may be frowned upon. We can also look at a pattern or practice of persecution of people who are similarly situated. And this came out of a case back in 2005, and at that time there were many Chinese Christians from Indonesia in the United States who were claiming asylum because they were being discriminated against in Indonesia just because they were Chinese Christians, Indonesia being a majority Muslim country. And so therefore, in the case that came out of Lee versus Ashcroft, or the decision that came out of Lee versus Ashcroft, the court said, we can look at a pattern and practice to determine whether or not there is persecution here. We didn't win that case, but it gave us a groundwork that we could then use in terms of other cases. So just going to go through to give you a clearer idea, but not really, of what persecution does not include. And even in terms of these things that are listed here, discrimination, harassment, prosecution, I always say, well, actually, it depends, right? It's that famous legal response, it depends. Because you have to look at the facts of the particular case. So the facts of the case may be talking about discrimination, right? But if there's a pattern and practice of discrimination that you could say rises to the level of persecution, then yes, it would be persecutory, right? So even though you come across a particular activity which you might think does not rise to the level of persecution, always remember that it's a depend situation. You're going to look at the facts of the case. Civil war, just wanted to highlight that for you. Just because there is a civil war in a particular country doesn't of itself mean that there is eligibility for asylum. You still need to demonstrate all the factors that are required. So going back to the slide that Jonah had, where we had matter of Mogarabi, which gives us all the different things that we have to establish. If you are in a situation of civil war, you still need to demonstrate that the persecution or the harm that you are suffering is because of your particular, because you fit within one of the 5 grounds, for instance, and some of the other factors that we will also be talking about today. So again, doesn't include harm or suffering inflicted by individuals unless acting as a government or the government is unable or unwilling to provide protection. So there must be some government involvement here. They don't have to be the persecutors, but if you can demonstrate that you are being persecuted by an individual and the government is unable or unwilling to provide you with protection, then you may be able to establish that you should be provided protection in the United States. A classic example of that we're dealing with right now is what's going on in Central America, right, with the gang activity there. There is so much information that essentially says the governments are unable to control this situation that's occurring in their countries, even though they want to. And even though they may have legislated, and even though they may be trying to arrest people that are involved, it is very clear that they are unable to control the situation that is in their country. The reason why people are not able to get asylum comes to something else that we'll be talking about, and that's whether or not they fit within one of the 5 grounds, okay? So we'll be talking about that. Criminal punishment for violating laws. Yes, Carol.
So, for example, in Haiti, several times he complained about gang activity in Haiti and also saying that the government is that be similar to
no, I mean, I think not really, just because the Central American situation is so pervasive and so clear. Haiti is a different situation. So the other issue that you have to be really mindful of is whether it is actually persecution or it's an issue of crime, right? Criminal activity. The government is always going to try to present this as if it is merely criminal activity, and so therefore there is no protection. And that's, I mean, you can say that in Central America it's criminal activity, right? But obviously that's not the way that we want to cast it, and we want to show that, and in Central America, I mean, the gangs are so organized that you can essentially say that, you know, these are subversive groups. We have not been that successful in terms of the gang arguments, but it doesn't stop us from continuing to argue and try to push that door. So I would say, in terms of what's happening in Haiti, I think it depends on the particular facts of your case, and it may be possible to argue that this is not just criminal activity, but that's going to be the first defensive argument that the government's going to bring in these types of cases. Criminal punishment for violating laws. So persecution doesn't include the punishment, but it depends, right? So if you can demonstrate that the punishment that is being meted out for a particular criminal activity is way beyond what is typically given, such that it might actually be a way of punishing someone for their political activities, there is the possibility of demonstrating that the act is actually persecution. An example that I like to give is Russia, and I never remember the guy's name. There's a particular thorn in Putin's side who has been held in prison because of his political activities, but he was charged with a criminal offense. So if he ever manages to get out, I would say that this is a great case that I would like to litigate for asylum. Okay, so just to give you a quick case for discussion, and I'll just read this just because of time. Sharif is an Iranian national. He's Baha'i, a minority religion in a country where Islam is dominant. Sharif could not apply for any government jobs nor obtain a business license, all because of his religion. Private employers would not hire him, and as a result, he remained unemployed for long stretches of time. Sharaf's children could not attend the local public school because of their religion, and his non-Baha'i neighbors often harassed his family. Because of the difficulty finding employment, the family was very poor and found it almost impossible to earn a living. Is Sharaf merely a victim of discrimination and harassment, or would his situation rise to the level of persecution? Any ideas and suggestions? Yes. Okay. Yes, yep. Right. Okay. So when you say that because of his religion, right, you're going on into the on account of one of the 5 factors, which we would need to establish. But what we're really looking at is this activity, does it rise to a level of persecution, which is separate from the reason why he's suffering all of these different activities, right? So he's not able to get a job, doesn't get a license, has difficulty educating his children, neighbors are also harassing him. So essentially here it looks like harassment, discrimination. The question becomes, can we make an argument that this activity is so pervasive that it should be considered persecution? And remember, we go back to matter of Acosta, it's a threat to life or freedom, right? And so here, the issue for Sharaf is that he's unable to support his family in this country because of the activities that he's having to experience. And so I would say that, yeah, I mean, there's a strong likelihood that you could make an argument that this is, in fact, persecution. And then you can go on to the because he is Baha'i. Yes.
Would our government maintain that a guy like this, in so many other cases, maybe he's an urban dweller, that he could move into the countryside and live a subsistence life as a farmer, and no one would bother him, therefore he's not being subject to subject categorically to discrimination in the country, that he should stay home in this country rather than come here because he can get a living as a farmer or fisherman?
So one of the requirements of establishing eligibility for asylum is demonstrating whether or not you have tried to relocate, right? So someone who has suffered past persecution, such as, let's just say in this particular example, we're making the determination that Sharaf has suffered persecution, right? So he suffered persecution in the past, okay? He also has to establish whether or not he's likely to suffer persecution in the future. And part of that argument is him saying, there's nowhere else in Iran where I could live safely, right? Or I could, support my family, right? And so then that requires an examination of, well, just how easy is it for him to go off and be a subsistence farmer, okay? In some communities, you need to live with a particular community. If you go outside of your community, that new community will identify you as being a stranger, if you like. And so they may also say, well, you're not welcome among us, right? So I think what we have to do is try to think of the situation for many outside of the life experience that we have, right? For us, it's easy for, not easy, it's possible for me to move from Philadelphia to Chicago and set up a life, right? In many countries, it's not that easy. And you need a network. You need a family network. You need a religious network. You need all kinds of different support systems to make that move and the creation of a new life possible for you. So the actual requirement is it reasonable to expect him to go off and do all of these things? And it may be reasonable and it may not. Those are all arguments that you have to work through. Okay.
Yeah, just to actually add on that, because I think it's a good question, and that's sort of known as like the internal relocation alternative in more academic circles, I guess, and also in some of the case law. I mean, and there is actually provision in the regs that kind of defines sort of a multi-factor reasonableness test. Because you can imagine the sort of extreme of that
example, that scenario you just laid out, where your government says to a group of people, we're going to burn down your houses, we're going to beat you up, we're going to kill you if you're occupying this, fertile piece of land, but go live up on those mountains somewhere and we'll leave you alone. I mean, that basically is the definition of ethnic cleansing, which in and of itself is persecution. Obviously there's a broad scope there that you have to figure out where your fact patterns fit into. Okay, well-founded fear. Again, turning back to the element of the definition, a refugee must have a well-founded fear of persecution. You have to sort of flesh out a little bit more about, sort of the nature of their fear. We do usually say that there are sort of subjective and objective elements to that definition. So a matter of Maghrabi is the BIA decision. Just an aside, this is maybe obvious, the BIA is the Board of Immigration Appeals, so that's sort of the administrative appellate body that decisions by immigration judges get appealed to before it gets kicked back out to the circuit courts. So the subjective element, so a lot of this case law, gets developed at the BIA level. Some of it makes it up to the circuit courts, and sometimes there's this kind of back and forth between the BIA and the circuit courts, which, gets muddled with all these admin law concerns like Chevron and Brand X. But the subjective element is you're looking at the applicant's state of mind to determine, whether or not the fear exists. When an adjudicator is kind of, looking at the well-founded fear question, this sort of gets into some of these sort of evidentiary aspects of making an asylum claim, but credibility of the applicant is extremely important. So basically, an applicant is going to need to, convince an immigration judge, an asylum officer, or even if they're a refugee in a camp trying to get resettled, a UNHCR or State Department officer, that they have this fear, that they can articulate it, that they can talk about it and explain it to whoever is making the decision about their case. But then also, of course, that fear has to be objectively reasonable. It has to be in a particular context so that the fear sort of makes sense. and this is sort of a would a reasonable person in similar circumstances feel afraid. And so this is when you're getting to, again, sort of a little evidentiary aside, you're looking at, what is the objective evidence, what is existing in the country. So, the classic two components of an asylum application is going to be, your applicant's story, what happened to them, how can they, convincingly can they tell the story, and then also the country conditions material. You're going to put together country conditions reports, stuff from the press, stuff from nonprofits, stuff from the UN that explains, oh, I think that her mic is still on, that still explains, both what the particular applicant's story is, but then also, what is going on in the country that they're running away from, so that you can cover both aspects of the well-founded fear definition. Excuse me. So also when discussing well-founded fear, we can talk about this is sort of one of those levels where kind of the different elements of the definition can sometimes bleed into each other a little bit, but when we talk about, persecution and sort of, the violence that's being inflicted upon somebody, it's, usually there's some belief or characteristic that, that persecutor is trying to overcome, is trying to defeat, or is trying to destroy in, the very worst cases of persecution. So when you're talking about well-founded fear, that touches on also sort of like the visibility of the applicant, the awareness or ability to become aware of, whatever ground that the persecutor is trying to overcome. So that is part of the well-founded fear calculation in that, you're going to have to convince the adjudicator, both that you meet all these other definition, elements of the definition, but also that the persecutor, the person who's going to, get you if you're in the country of origin, knows that you're a member of this group, has sort of the proper motivation, the ability, and the inclination to attack you, to harm you. Another aspect of persecution is the role that past persecution plays. You can generally categorize asylum applications into two kind of groups. There are cases where it's a purely forward-looking examination. If I go home, I will be persecuted. Or if persecution has happened in the past. I've suffered past persecution, and then that gives rise to certain sort of legal presumptions. So if you've been persecuted in the past and you can document that to the satisfaction of the adjudicator, in most cases you can then sort of benefit from a rebuttable presumption that you will be in danger of persecution if you go back. So in immigration court, that literally means that the burden will shift over to the ICE attorney to sort of make the case that you will in fact be safe if you get sent back. And then you're talking about, has there been some fundamental change in circumstances in the country? Has the government changed in a fundamental way? And this also gets back to sort of the internal relocation question that can come up during these conversations. So the government might say, well, we think there's a new government, it's not as bad, so they're going to be safe going back. Oh, and also, they can relocate to, this city 500 miles away from, where they were first imprisoned, and they should be safe over there. So these are sort of the ways in which the ICE attorney will, attempt to sort of defeat the past persecution component. But obviously, that's just a purely legal sort of advocate role. If you have proof of past persecution, that's a pretty powerful tool in proving that case. And as with any aspects of an asylum application, that can be based purely on their credible testimony. Just to get, again, into the purely evidentiary stuff. So, the federal rules of evidence, thankfully, do not apply. You don't have to worry about hearsay evidence or any of that kind of stuff, because frankly, without hearsay evidence, like hardly anyone would be able to make an asylum claim. But, you're looking at sort of, the credible testimony of the applicant, as I said before, But then you're also looking at, so for past persecution, what can also be very powerful is, you know, possibly medical evidence. You know, is there signs of torture like on their bodies? And that's where, you know, you might be partnering up with a doctor who can actually do a medical report and sort of, you know, document scarring, broken bones, things that are consistent with, you know, a doctor would never responsibly say, oh, I know this person was tortured, but they can say they have, you know, artifacts, they have signs on their body that are consistent with physical abuse. Humanitarian asylum. This is a sort of a subset of sort of the past persecution theme in that, and this is the idea that it's not explicitly in the treaty, but almost from the get-go in asylum law, this is in refugee law, this has been a pretty powerful concept, and I think it comes directly out of, you know, the history of the convention. After World War II, no one was going to make a Jew who fled the Holocaust go back to Germany, go back to Poland, you know, even if obviously, you know, the Nazi government had fallen, right? There had been profound regime change. However, what had happened to them in the past was so horrible that, you know, this idea of humanitarian asylum came out. You can almost think of the idea that, you know, to force that person to go back just because of the psychological trauma that they might suffer, in and of itself is a sort of a gross violation of humanitarian norms. So we do have this concept of humanitarian asylum in our law. Matter of Chen is sort of the big BIA decision. We've also got, yeah, the Third Circuit side up there. And it's basically, it's just, you know, kind of an examination into, you know, does the past persecution kind of meet a particular level of awfulness, frankly, where the, you know, adjudicator feels that they can just grant asylum based on what's happened in the past without having to sort of go into what might happen in the future. Evidentiary standards. So there was a pair of Supreme Court decisions in the 80s. I think, as I mentioned before, that all of this stuff really got baked into the INA and into the Title 8 of the Code with the Refugee Act of 1980. It's also what established the entire refugee resettlement system. So there were a series, some of the earlier Supreme Court decisions on this stuff comes from the mid to late 80s. There's sort of twin cases, and we'll touch on both of them. You know, Stevick and Ines v. Cardozo Fonseca that deal with evidentiary standards. The basic standard that we're looking at is, you know, sort of the reasonable possibility of suffering persecution. You know, the well-founded fear sort of standard. You know, whenever we're in law school and we're talking about, you know, the standard in civil court, standard in criminal court, you know, you're always kind of trying to put percentages to it. It's a little bit more amorphous in asylum law. So the 10% chance of harm or persecution, I mean, so that's sort of, so this is Justice Stevens wrote this opinion. And the 10% comment is, you know, the point he was making is, you know, if you had a 10% chance of when you disembarked from the airplane in your home country and, you know, your government immediately executes you on the runway, you know, that should, even though it's only a 10% chance that that's the harm that's going to befall you, you know, that should still be enough to make a claim of asylum. So it's not just the percentage of the harm happening, but it's also a more kind of complicated multi-factor examination of both how likely is the harm and also how bad is the harm. Which I know in terms of, as you can imagine, when you're actually, you know, trying to brief or adjudicate this stuff can get very fuzzy very quick. But, you know, I think the fundamental point there, you know, is powerful, that it's not just enough to look at, you know, what are the chances of this harm befalling you. And that is the end of my spiel, and now you get IO again.
So I would just add, with respect to the 10% chance, essentially with respect to asylum claims, the evidentiary standard is supposed to be fairly low, right? But the actual fact is that the judges are holding us to just less than 50%. So I'd say, you know, actually when we're preparing these cases, if you're doing it well, you're preparing the case to go to the Third Circuit, right? Because there are just a number of these cases where you can pretty much be confident that the immigration judge is going to deny you. You're going to have to go up to the BIA. And at the BIA, you may get a favorable decision, you may not, but you need to be prepared to go to the Third Circuit. Third Circuit is only doing a review of the record, so you want to make sure that your record is completely, everything that you are trying to establish is well documented. So we don't actually present these cases as though we are just dealing with a 10% chance or a very low chance. We deal with them as if, I mean, I have to say I sort of work on a more likely than not standard, which is not the standard at all, but is pretty much the standard, almost the standard that's applied in immigration court. Yes? So, hi Susan, I just saw you. That's Susan Balfour, she's the director of the Asylum Office, Lyndhurst, and she's going to be presenting later on this afternoon. So it depends. You're going to hate me because all the afternoon I'm going to say it depends, right? So some people are actually going to have a past persecution-based claim, right? Because something happened to them before they came to the United States, right? And so, but even if they have a past persecution claim, they still have to, so once you establish past persecution, right, it becomes the government's burden to show, to rebut that there's, you know, the likelihood of future persecution, because you get that presumption. You don't have to establish it, right? But the way that we actually present cases, you don't have bifurcated hearings, right? So let's say we've got a defensive application. So you don't have this bifurcated claim where the judge holds a hearing and says, okay, show me past persecution. You've established past persecution. Now, government, demonstrate that you can rebut this. Oh, you rebutted it. Okay, you now have, no. It all happens at once, which is what is really sort of awkward. So you have to go into court, even though you don't have this burden with respect to a rebuttal in terms of future persecution, you still need to go into court prepared to demonstrate that actually the government's not going to be able to rebut this because of X, Y, and Z, right? That's if you've got past persecution. If it's a future persecution case, right, that's separate. And that's because you don't have any factors that you can demonstrate that would establish past persecution. And so then you have that track, as you said, in terms of establishing your claim to asylum. Does that make sense? Yep. Okay. So just because you have suffered persecution, right, past persecution, or you have a well-founded fear of future persecution, doesn't automatically demonstrate that you qualify for protection. You have to show that the persecution that you have experienced is for one of 5 reasons, and only these 5 reasons, right? So if I say, you know, I suffered persecution because I was singing in the bath and I'm a terrible singer, and so, you know, my neighbors, then it doesn't matter, right? Not every abhorrent behavior qualifies for asylum. One of these 5 reasons, race, religion, nationality, political opinion, which can be your political opinion or one that is imputed to you, right? So your persecutor thinks that you have this particular political opinion. And that happens a lot with family members, right? So it may be assumed that you have the same political opinion as your father or an uncle who may be politically active, right, in terms of imputed. And then you have this membership in a particular social group, right? And I'll get to that in a moment. But people often ask, when you say race, what does that mean, right? Because hard to understand what that is. And so I've given you some examples, some ideas, okay? So in Mauritania, you've got a black majority, Arabic minority. The black majority is persecuted, or at least experiences severe discrimination in Mauritania, right? Sudan, you have a similar situation. Burma, Myanmar, you can talk about the Rohingya minority, right, to put it into today's terms. Rwanda, Hutus and Tutsis. South Africa, we know that history. So that gives you a sense in terms of a race-based claim. The area where there is the most litigation in terms of one of these 5 grounds is membership of a particular social group. And that is because, once again, there is no definition of what it means, membership of a particular social group. But it also doesn't include everything else that is not race, religion, nationality, or political opinion. So when you're dealing with a particular social group claim, you have to really think carefully about how you want to define your particular social group. We have some guidance, and this comes out of much litigation. So we started off with ACOSTA, which gave us some very clear guidelines in terms of what we had to establish if we were trying to make a claim that was based on a particular social group. Immutable characteristic or common trait, which may be innate, such as sex, color, kinship ties, or shared past experiences, things that you shouldn't be required to change, right? Fundamental characteristics that cannot or should not be required to change. And the group should be socially distinct within the society at large. That's what we got from ACOSTA. But since ACOSTA, there has been much litigation, as I've said. I didn't give you the history of how we got to where we are right now. But if you do get a particular social group claim, you may want to look at the history, simply because, at least in the Third Circuit, this issue is not resolved yet. Okay? I'm sorry. But the leading case that we have from the Third Circuit, or the leading cases that we have, a matter of MEVG, a matter of WGR. MEVG comes out of a Third Circuit case, Valdivieso Gomez, which was from 2011. And so now the board says, we're not going to just apply ACOSTA, we're going to add to the requirements from ACOSTA. So now we have to demonstrate that the group, the particular social group, is composed of members who share a common immutable characteristic. We recognize that, right, from ACOSTA. The group has to be defined with particularity. I'm going to get to that. And the group has to be socially distinct within the society in question. So you now have these 3 characteristics that need to be established when we're talking about a social group. As I said, this issue is not resolved in the Third Circuit. And one of the reasons why it's not resolved in the Third Circuit is because nobody really understands what defined with particularity means, right? And how that is different from socially distinct within the society. The other problem is that these additional requirements now place a burden on the applicant, right? How would you go about demonstrating that a particular social group is socially distinct within the society in question? That's a question. It's not a rhetorical question. I'm asking you. Yes.
I guess in certain ways, it's sort of organized with forms of very visible groups. For instance, I know this has come up, like street children, children who live on the streets, homeless population. Anyone knows that, or people like segregate themselves in certain ways. If you have the cross dressers, right? So that's not necessarily transgender, it's not necessarily a physical component there, but you need to dress differently so they're treated that. I guess the visibility would be the best thing to do, but so when you show that is you know, talking about it, social media component to it, or news article, or study, and how else do you show it unless you don't want to interview people in your home country?
Okay, so the examples you've given are ones where you're looking at visibility, right? They're distinct because they look different within the society, right? But let's talk about FGM, or women who are opposed to female genital circumcision. How would you, is that a visible group? Or those who, you know, another group that's been identified in the past, homosexuals. Is that necessarily a visible group? So when you look at the requirement that they have to be socially distinct within the society, typically this is requiring, excuse me, either you're doing country conditions research on the internet, and if it's a large enough country, a recognized group, you may be able to find that information, right? But if you can't, then you're looking to an expert. Excuse me. You're looking to an expert, which then requires additional resources. You've got to find the expert. You've got to hope that the expert is going to be willing to work with you for free. They don't always, right? So that's additional money that you've got to find in order to be able to establish your case, right? In some cases, the expert might be an anthropologist, right? How is the average person or the per se litigant going to find those kinds of people, or even know that they have to do that? So this is an additional burden that's been placed through the decisions that we have right now, but we have to deal with it, right? Carol.
What about women who are subject to forced marriage? Would that be considered a socially distinct group that is defined as
Well, I didn't get to particularity, right? I'm only looking at social distinction, right? And so I'm going to say, well, it depends, right? Because you've got to look at the society, right? And it may be that within that society, yes, women who are forced into marriage would be considered a particular group, right? And I would certainly argue that that should be the case. But in order to establish it, you're going to have to present evidence that that is so. And so it becomes a question of, well, what is the evidence that you're able to find? If you're talking about a country like Burkina Faso, which is very small, is there a lot of material that talks about that kind of activity? I don't know, because I haven't had to do the research. But if you could find it, and it's clearly established that, yes, this is a particular socially distinct group, great. But if not, you're going to have to find a political scientist, maybe, who has done some studies around this, who can then write a report that supports your idea that, yeah, this is a socially distinct group within this society.
But the question is, what if it's pervasive, that it's clearly established that that's the custom in that particular country, is that young women who reach a certain age, 16 to 18, are, married off to the parents' choose or father's choose. And it's pervasive. So would that, you have to show some kind of persecution. Would that be considered persecution?
Well, we're not talking about the persecution piece. We're talking about the social group, right? All of the different parts, right? So whether or not it's persecution is going to depend on the girl, right? Is she, as you're saying, this is a cultural practice. Is she supportive of this cultural practice, right? If she is, would she consider it to be persecution? Because remember, you have to have the subjective and the objective elements, right? So if she doesn't consider it to be, then you've lost that one piece, right? But if she thinks that it is a form of persecution, right, and you are able to establish this social group, right, and you meet all the criteria in terms of demonstrating this social group, yeah, you may be able to demonstrate that she should be granted asylum, right? So you've got all of these different steps that you have to go through in terms of establishing a claim to asylum. And the social group is one element, the persecution is a separate element, and you've got to go through all of those. Excuse me. Yeah. Yes.
I just had one quick thing to that last question. I think just as a practical matter, particularly the gender-based claims, that adjudicators have been, and the court in this guy have been reluctant to, in any context, allowing a social group just to be, all women within a particular society. If I were the judge in some of these countries, El Salvador, Guinea, or whatever, I'd be perfectly happy to say your social group is women, period. Move on to the next step. But fortunately, we don't like that. There are some of these like, limiting decisions. Some cases that come out of that they qualify as women of a particular age, of a particular tribal background, et cetera, et cetera.
And it gets to the point where you're sort of defining this group so that it basically includes this one person, right? Which is quite ridiculous. But, in terms of not having this broad-based women of, I mean, does anybody know why we're not doing that? Or why we're not allowed to do that? That's not a rhetorical question I'm asking. It's the floodgates argument, right? This is always the issue. Well, we can't let everybody in. But if you look at the convention, if you look at what we have signed up to, right, we have signed up to provide protection to anyone who can establish that they need protection, right? So introducing these artificial and arbitrary limits, basically, from my perspective, means that we are not following through with the obligations that we have signed up for. It's a problem. We keep pushing. Judge Morley did grant a case which was women. So we just keep pushing, and who knows what will happen. That's what lawyers do, right? Yes. Yes, I will. So, yes, for the longest time, we kept pushing to get domestic violence, or those who experience domestic violence, recognized as a particular social group, right? And so in 2014, we were able to do that. But the language of the case, this particular case, ARCG, was married women who, the language is not exact, but it was basically married women who are unable to escape their long-term relationships or something like that, right? But this case gave some great guidance in terms of what we can provide as evidence when we're trying to establish the social distinction, right? This case came out of Guatemala, Central America. The history of Central America with its civil wars is really, to me it's fascinating. But it talks about the treatment of women coming out of the civil wars, right? Because during the Civil War, women were really objectified, harmed, killed, and that behavior hasn't necessarily changed. It may have reduced, but it hasn't necessarily changed. And in Guatemala, the government actually recognizes that there is this real problem of violence against women. Also in Honduras, right? So you have these countries that are recognizing that they have a problem, but there is nothing effective they can do about it. They're making efforts, but they cannot do anything effective. And so therefore, in this case, it was saying, if you have statements from the government that recognizes that this is a problem, right, that can help you to demonstrate the social distinction, that this group is socially distinct, because even the government is recognizing them as being socially distinct. I just did this case for a client who was from Mozambique, similar situation. The government, I think in that country, I think it was like the daughter of a former president was killed by her partner, right? And you have the government saying, yes, we recognize that we need to do more, we recognize we have these laws, we recognize that the police are not doing anything, okay? That's like your classic case, right? And that's the ideal. You want the government to say something like that, and then you really do have an ARCG situation. But it's not always that clear, because you know, governments don't always want to recognize that they're incapable of coping with things. Anyway, so social group, as I said, an area with much litigation. I'm going to skip the case for discussion and come back to it just because I want to give you some examples of cases where social groups have been recognized. So your family relationship, I mean, actually get this Third Circuit case, and there's a recent BIA case, which is not here, but it's recognizing the family relationship as a possible social group. Clan membership, right? This case, Matter of H, came out of Somalia, where you've got all these different clans, you've got the larger clans, the minor clans, so that demonstrated, or that was a case that identified clan membership as a social group. Sexual orientation, so Matter of Toboso Alfonso came out of Cuba, homosexual who was being persecuted by the government. Yes, Carol? Family, your membership of a family group. So let's say, so I mean, do you remember what the recent BIA case is?
Yeah, I was trying to remember that.
Okay, so but in that case, it was the father owned a store, and there were gangs. I mean, this is sort of like, these cases are complicated because there's this whole, as I said before, it's this whole issue of whether or not it's pure violence or whether it is actually persecution. So the father owned a store, and the gang members came to the father and asked him to give them, you know, money. They then started to target the son, right? Son is a member of the father's family. His argument was, they are targeting me because I'm a member of this family, right? I don't think he actually won the case, even though that we had the presidential decision that defined family as a social group, because in that particular case, the board found that actually, no, it was all just part of this violent criminal activity. But that's the relationship.
Yeah, I got a case, for instance, where a little bit strange, but there's a young man from Togo who, because of who his father was and who his grandfather was expected to join this particular priesthood. Because he got abducted and he was recently cut, a lot of those awful things happened to him, and he resisted and kept on snatching him up and really horribly abusing him. So there were a couple different grounds we worked in that case, but one of the big ones was, you know, this sort of family relationship, because this priesthood position was supposed to be, you know, passed down through the father and son, and he sort of rejected that.
And that's, so I mean, yeah, I mean, I think I remember that I had given a case to a pro bono attorney, which was similar to this. It was a Liberian case, and also in Liberia, you have these different sects or different groups. And people are identified as being the next one in line to take over from a parent or a grandparent. And within the, I guess, indigenous religious activities that happens in those countries. Yes?
I remember that case that you were talking about, that they just targeted somebody that had access to the story or access to the money. But isn't this family relationship also able to be used for when threats are made against the family members? If they're like just made against the children, or killing children, and you know, that child now has a claim because the only reason they were threatened was because they were the child of that man, not because of the other stuff. You know, you're saying some other things about, like, you know, the expectation of the family, or but just like a direct threat to that, you know, relative, only because of somebody.
somebody else's activity, yeah. Although you also have to be careful about whether, whether the threat itself rises to the level of persecution, right? Because there's I can't remember the Third Circuit case, which talks about, there has to be an imminent danger element, right? And does that exist necessarily with a threat? And I know we have a case at the BIA right now because Judge Morley decided that the threats to the client weren't imminent, didn't demonstrate imminent danger. So yes, it can be because of what's happened or because of the threats that are made to this child because of the activities of this other person. In terms of if you're using a family relationship for your social group, but you still have to look at all the other elements as well to determine whether or not you can make a viable claim for asylum. Okay, just to go through quickly, gender-based, matter of Kasinga, 1996, Zubaydah, Third Circuit. Zubaydah was the rape case, identifying that as a social group. Matter of AT. Matter of AT is actually very interesting, and if you have a chance, you should take a look at it. It actually has, I think, 4 different cases, because it started with the immigration judge, it went to the Board of Immigration Appeals, where they basically affirmed the immigration judge's decision. Then the Attorney General, who always has authority to take cases to him or herself, looked at this case and came up with a different decision. This is one of the FGM cases, and what the board essentially said was, you have suffered past persecution, but there's no likelihood that you will suffer future persecution because you're not going to have FGM a second time, which is actually factually incorrect anyway, because FGM can happen more than once. Often what happens is that, after a woman is stitched up, if she becomes pregnant, she gets cut so that she can deliver the baby. After the baby is delivered, she gets resewn. So factually they were incorrect. But the Attorney General said, when you're looking at past persecution cases where someone has established past persecution, in order to determine whether or not there's a likelihood of future persecution, you are not just looking at the persecution that they suffered in the past. You can look at other factors to determine whether or not they are going to suffer persecution in the future. Okay, so that's a really good case to take a look at. If you're doing gender-based cases, this 1995, a very old policy memorandum, which was supposed to have been updated, never has. This is the most recent document that you should look at to give you guidance in terms of how the Immigration Service is looking at these types of cases. Just going to go back quickly to this case for discussion. Denny is an ethnic Chinese citizen of Indonesia. He was raised as an evangelical Christian. Denny discovered he was attracted to men when he was 15. He joined an informal group of gay activists who shared experiences and attended support groups. Their eventual goal was to work against discrimination and stigmatization of gays in Indonesia. While Denny was coming home from a support meeting with a friend, 2 members of the army attacked and badly beat him. They yelled, "Filthy sinner woman," at him. Sinner was considered a derogatory racial term for the Chinese. Denny tried to report the incident to both the police and army, and neither would accept the complaint. Instead, they told him to be careful. They openly declared that there would be no place in Indonesia for unnatural people like him who defied Islam. Denny's family disowned him because they also considered his sexual orientation to be a sin against their religion. If Denny applies for asylum in the United States, which of the enumerated grounds, if any, would apply to his situation? And remember, it's if there is more than one ground, you would be looking at each one. Any ideas? Yes.
I would say that the political opinion would be around is the fact that he's an activist trying to change laws that he won, but the actual act of persecution was done on the basis of his orientation. So then I would seek to classify him under social.
Any other suggestions? Yeah. Okay. Any others? Carol? Mm-hmm. So, I mean, I would say yes. All of those are different elements that would need to be explored, and possibly filing applications based on all of those different enumerated grounds, right? The particular social group, religious, race, political opinion, but remember, you also, so it's what is your persecutor able to perceive in terms of the persecution, right? And so if they were seeing him in all of these different categories and persecuting him for all of these different reasons, absolutely you would include all of those. And then it's for the asylum office to sort it out, or the government, or the judge to sort out which ground. Very rarely do they say, we are giving it to you because of your, in these types of cases where you're raising more than one ground, unless they are they think that some of the grounds that you've raised don't actually apply, they usually say, yes, you know, you've been granted asylum. Boom. And that's all you care about, right? You don't care what, you know, well, some people do care on what basis, but typically you don't. Criteria for social group, that you're a member of that cognizable social group, that there's a nexus between your group membership and the harm that you fear. So it has to be because of the harm that you fear has to be because you are a member of this group, you're within this group, that the harm feared is sufficiently severe to constitute persecution. So once again, you have to have that persecution as part of the, you have to demonstrate that it rises to the level of persecution, the harm that you're experiencing, that the harm is sufficiently likely to occur if it's a future persecution case, government unable or unwilling to protect you, applicant can't relocate. So we're sort of combining all of the different elements that you have to establish in order to qualify for asylum. None of the statutory bars to protection would prevent you from actually qualifying and being granted asylum. We're going to look at the statutory bars later.
Okay.
Yeah, and one actually quick follow-up on the, you know, the social group cases that we just talked about. Well, two quick ones. Is one, in some of these more complicated ones, it is actually worth going back. I'm thinking particularly the matter of AT and ARCG, and sort of tracing the steps that these things came about. Because again, a lot of this action is happening, you know, at the administrative sort of state level. It's, you know, within the Justice Department. But you can actually get these sort of dialogues happening between the immigration judge, the BIA, sometimes the Attorney General, you know, directly stepping in as in matter of AT. Sometimes parts of this get kicked out to the circuit courts and remanded back. You get these very complicated procedural histories that I think can sort of explicate sort of how these decisions get made. So ARCG, for example, oh God, I don't even remember the entire history. I mean, I think at one point there was a BIA decision. There was also an Attorney General decision. Ultimately, when the Obama administration came in, DHS, so the DHS attorneys sort of drafted a memorandum sort of pointing out, you know, various grounds on which they thought this social group could be articulated that eventually the BIA adopted. So there's just there can be a lot of moving parts there, and if you really want to understand kind of where some of these things come from, it's worth reading all that, especially in the ARCG context, because that DHS memo that the BIA based their decision off of actually had some alternative grounds sort of for how to articulate it. And sometimes, you know, using those alternatives as sort of persuasive authorities, you know, can be helpful for particular cases. Excuse me. It's that time of year we're all just like sore throats up here. So I'm going to sort of swing back to some of the evidentiary questions. I sort of previewed a little of this before. So corroboration, the Real ID Act is actually not only, you know, the law that's going to make all of our Pennsylvania driver's licenses useless for getting on airplanes in a couple of months. There is components of it that touched on asylum law, and basically just sort of requiring certain sort of evidentiary standards to be met in, you know, before an asylum officer, before an immigration judge. So having to do with corroboration of evidence. So again, testimonial evidence can get you, you know, all the way to an asylum grant. Obviously, as a practitioner, you want to back that up with something else. You hope not to be in the position, certainly, of just having to rely on testimonial evidence. But if testimony is credible, if it's persuasive, it refers to specific facts sufficient to demonstrate qualification as a refugee, you know, then you can get there. You know, judges may, you know, require corroborations. That's, again, something that sort of the Real ID Act did, is, you know, judges being allowed to sort of do these kind of second-order inquiries into the evidence that's being proffered. So the judge might say, well, it seems to me like you should be able to back up what you're telling me with this, this, and this, but you haven't shown me that, so why not? So these are, it sort of lets the judge kind of do a little bit deeper dig into the evidence, the quality of the evidence, and kind of ask kind of reasonable questions about, you know, what you have presented and maybe why you haven't presented something else, if that all makes sense. And then there's sort of, you know, there's some techniques we can use. We can authenticate documents, excuse me. It's not that unusual that we'll get, well, you kind of get both, right? So in many cases, people are running away, they're fleeing persecution, they're not going to take time to, they're not necessarily going to have the time to sort of pack a briefcase full of evidence. And it's also, shockingly, very unusual for a persecutor to, you know, write it all down in a neat little memo and then, you know, give it to the persecuted person to take with them so that they can make their asylum case. You know, usually it's much murkier than that. But sometimes you're going to have clients, applicants who have, you know, an arrest warrant. They might have, you know, pieces of documentation from some court proceeding that happened against them. You know, they might have some in-country medical records where the doctor might have, you know, scribbled some notes on, this guy came in bleeding, he told me he got beat up by police, you know, things of that nature. Of course, you need to convince either the asylum officer or the judge that these documents are genuine, that they have not been forged. So sometimes, you know, things can be authenticated. And, you know, again, you're sort of turning to experts to try to do things like that. You can try to get certified copies of documents. Again, you're sort of, you know, you're always relying on, you know, whatever sort of the document bureaucracy of country X is. You know, if you might get a notary stamp from some country, but then, you know, you'll need the, you know, the adjudicator to sort of accept by whatever process that stamp was procured. So there can be, yeah.
So
affidavits are absolutely admissible. In fact, affidavits are kind of usually the core of any application. Well, like I always depends. So the basic components, especially if you're in front of an asylum officer, is it's going to be both an affidavit and then also it's going to be the applicant's testimony. There are mechanisms by which you can bring in witnesses. Now, when you're talking about, so usually with something like a Skype, you know, witness, you're probably not going to be able to just logistically work that out at the asylum office. They could figure that out at immigration court. You know, I had a Syrian client who had fled ISIS-occupied Damascus, and I thought I felt really lucky because I'd lined up actually an old friend of a friend who was a UN employee who had lived in Damascus throughout, you know, through the first 4 years of the Civil War. And I actually had him, he was holed up in a hotel room in Beirut on the phone, ready to call in and talk to the court. However, the judge ended up well, the judge ended up, frankly, not needing his testimony. We got the grant, so no harm, no foul. But the judge was reluctant to allow this guy to just sort of call in on the speakerphone because he wasn't an in-person witness. He was like, well, I don't know if I can, I have no way of really assessing who this guy is, who this, disembodied voice is on the phone. So again, that's going to be a conversation with the judge. That's going to be, can you convince the judge to allow you to sort of, Skype in that witness or whatever. In some cases, actually, judges might be more happy with just a written statement, from this witness that has been notarized, that then has, various ID documents attached to it. Like we usually will, if we're having an affidavit sent in from out of country, we'll usually say, provide a copy of your national ID, of your passport ID page. You just sort of accrete as much authority to each piece of evidence as you can. But again, federal rules of evidence do not apply. I mean, it's a much more kind of, balancing test, does this seem right kind of test in a lot of these things, which, doesn't give you as much to go on, obviously. There are, it can be possible. There is a forensics testing lab in DHS where they sort of, I think they have sort of libraries of, what does an arrest warrant look like in certain countries, and they can kind of do comparisons and things like that. And it is possible to try to get that done. Expert testimony, again, this is sort of, rules of evidence-ish, but it's not, wholly different from, the rules as written down. Will a judge accept somebody as an expert? You're going to want to present credentials, present a resume. So the most common expert testimony that I use is from medical professionals, psychological evaluations and medical evaluations. And also, fortunately, their credentials are real easy. You just package a resume in with the with their medical evaluation, and usually that would do the job. And in most cases, 9 times out of 10, especially with physical medical evidence, psychological stuff, there's a little more reluctance. But with a physical medical report, done by a qualified physician, the government's going to stipulate to those reports in most cases. And credibility. So this is a huge one, in particular if you are at the asylum office. Since Ms. Ralpher is here, this is an extremely difficult thing that asylum officers are asked to do. Right? It's like they have to. It's almost like they're sitting in the role of a jury in a criminal case. Right? They have to make a determination about if this person who they've never met, who is sitting in their office, is telling the truth. And so how you assess credibility, and also in a very compressed period of time, there's a reading we like to assign in the refugee law class, which was written by 2 Canadian immigration adjudicators, asylum adjudicators, sort of talking about their process for figuring out credibility. And one of the things that jumps out to me reading this thing, it's sort of an interesting piece on how do you figure out what the truth is just from someone's story. But also these Canadian adjudicators, they work in pairs, and they have multiple days to try to figure this stuff out. In our system, it is much more truncated. You're going to get in there, and you're going to have a couple hours of this person's time in most cases to sort of get this story out. So it's a difficult job that they're being asked to do. I find myself strenuously disagreeing with some of the determinations they make as a result of these interviews, though, when I get referred, and I'll talk a little bit more about that in a second. But in terms of credibility, you're looking at demeanor, you're looking at plausibility. Is a story sort of internally coherent? Is it consistent? Does it match the country conditions? Can the client sort of paint a compelling and coherent picture of what happened to them? Now, you can think that, for some clients, this can be extraordinarily difficult. If you have a client who is suffering from post-traumatic stress disorder because of what happened to them getting their story out can be really, really hard, and them getting it out consistently can be, very, very difficult. I have one client who is so badly tortured that he suffers from traumatic brain injury. So he has a series of mental health problems that are, were a direct result of his torture, but it makes him sort of his ability to kind of tell his story is very difficult. So as an advocate, as an attorney, part of what you're doing, this gets back to, when we're talking about sort of I think really the centrality of the affidavit, is, you're going to work with that client, you're going to work with that applicant, and partly when you're taking this affidavit, you're recording their story, obviously, but you're also you're going through sort of a clarification process. It's like, you can take more time than the asylum officer is going to be able to do and be like, let's go through this story and make sure you've got it clear in your head. So, obviously we are bound by the rules of ethics. We are not planting ideas in our clients' heads. But, we're saying, now wait, let's go back to that previous, point you just told. I'm not sure if that quite makes sense. And you always want to be, and this is a delicate thing, you always want to be very clear that, do not make things up, do not exaggerate. That is really critically important. And it is okay to be unsure about stuff. You are allowed to say, I think this happened in August, but I'm not sure. I think it was summer. I think it was rainy season. But to try to get as clear and coherent a story down as possible. And again, a lot of that's going to depend on who your client is. Yeah, sorry, go ahead. So you can rely on affidavits, on statements from other people who would have reason to know they were there. One thing I like to do, so again, when I'm sort of developing these cases, it's, you do multiple rounds with the client, sort of getting that affidavit right and kind of figuring out what happened when. I like to build a timeline of the case, right, to as accurate as I can, literally just dates, and this happened, this happened, this happened, this happened, this happened. Dates as close as I can get them. Sometimes that's not possible. Then you also try to corroborate those events against country conditions research. So that's the big one. So if they say they were at a protest at this particular, square in this particular city, go to those press accounts. Can you verify that with a newspaper clipping, or even better, something that's in the State Department's, annual human rights report. You sort of go through each event and, try to figure out how that happened. And sometimes that gets muddled. Like I have some Mauritanian clients, and there are periods where there are like multiple protests by multiple groups going on in Nouakchott, like at the same, over the course of several days. And it's, it gets, were you involved in the University of Nouakchott protests, or were you in the, don't touch my nationality protests that were going on like a day and a half later, sort of down the street, and, sort of trying to parse out, where they actually were. Yeah, go ahead. Mm-hmm.
My question is more directed to the client
So you mean if the client is being sort of, has contradicted their own story in prior statements? You're going to have to ask the client to, explain that. Mm-hmm. Yeah.
There are different situations, different times in the time life of the individual, right? So somebody who arrives at the airport says that they are claiming asylum. They have to have an interview, right? It's called a credible fear interview. We're going to talk about that in a little bit. So everything that they say is supposed to be documented, okay? So you're going to get, or the client gets, a printout of that interview, right? So when you're doing the affidavit to the client, you've got to refer back to that prior statement to make sure that what's being said is consistent. When they were in detention, for instance, they may have already filed an application for asylum. So there's that, we're talking about the sort of 9589 and 40 others already on the file. You've got to check that and see, what did they say there? I don't think it's consistent with what they say to you now, right? More consistency, you need to explain it. If it's a completely different story, you need to explain it, and then maybe an explanation, right? But those are all conversations that you have to have with your client to make sure that you're not putting them in a situation where the government can produce a statement that they made previously, and then raise questions about that.
Yeah, and then there's actually a whole other universe of prior statements, which is if that client has made prior visa applications at U.S. embassies, you know, they're going to have made statements to consular officers. And that's largely undiscoverable by us. I mean, there's this whole body of, you know, Supreme Court law called the consular non-reviewability doctrine. Since embassies are overseas, you know, federal courts don't like to claim any jurisdiction over them. Someday I would love to successfully sue the State Department to try to claw some of that stuff back. It's a personal goal of mine, but I'm not there yet. Sorry, go ahead. Yeah, well, so you are. I mean, you're not required to submit the affidavit. You can make the application just on the 589. But as a matter of practice, absolutely, you should have an affidavit. And then when you either get to the asylum office or you know end up in front of the immigration judge, yes, there's going to be in-person testimony. So the way an asylum interview works is you know the officer you know sits on one side of the desk, the client, the interpreter, and you sit on the other side of the desk. And it is an interview. You know, as an attorney, there's not a whole lot you can do in these interviews. You know, I mean, you know, it's not like you can, you know, object or, you know, direct testimony in a particular way. It is the asylum officer's, you know, job to, you know, run that show. You know, obviously, if something is going very awry, you think the officer is being inappropriate, you can, you know, call in a supervisor or something like that. But I've never had to do that because, generally, you know, these people tend to be very professional. But so at that initial interview, it is.
I would say that yes, it is the asylum officer's role to run the show, but you are there to protect your client's interests, right? And so, so I don't know whether I should ask you to stand up front of you.
Yeah, I know, right?
I had an interview with a client who was from actually the client was another from Yemen. And the asylum officer, so they like to tell you that you cannot say anything while the interview is going on. You'll have the opportunity to speak at the end, right? I heard you. But, as you know, as we started today, I said, if you have questions, ask them in the moment because that's when they are the most valuable to you, right? And so during the interview, the officer was getting, anyway, I did not follow her saying, but so she was asking questions, and I felt that they were inappropriate, or they weren't really going to the heart of what the issues were, and so therefore I said, very politely, officer, may I offer this exercise in the moment, right? And then at the end, when it was officially my time to speak, you know, we were going through, and I was challenging some of the questions that she made through the client answering questions. And being able to answer. So I would say that you need to be paying attention to everything that happens. And unless it's something that you cannot resolve with the officer, then yeah, sure, call the supervisor. But you should be able to resolve issues with the officer right there and then. So it may be that I'm a little more.
Yeah, no, and I certainly didn't mean to suggest that there's you know no role for counsel in there. I mean, one critical role is you know you take notes because you know that is you know that is your record of what goes on is going to be, and you know you're not allowed to take a laptop in there, so bring your legal pads. And I mean it's not quite a transcription, but get down as much as you can in terms of your own notes of you know what went on in there. There's also a role you can play, I think, just in terms of kind of smoothing things along and kind of helping the whole process run smoothly, by which I mean, you know, if there's some confusion on a minor point, sometimes I can say, excuse me, officer, I think you're looking for this document in the record. This is going to answer exactly what you're trying to get to. And, you know, the officer will appreciate that. And usually, though, but you can also, you know, definitely get into a back and forth with officers where they're like, stop asking questions. Your time is at the end. So I can be pushy in these things too, but you're gonna get. Yeah. The other thing with credibility, and this is where I have, I think, a lot of criticism with, did Susan actually walk out? This is actually where I have a lot of criticism, I think, where the way in which asylum officers go about this stuff is that there's a very heavy, almost sort of, you know, totemic emphasis placed on, you know, consistency with like dates, times, and places. You know, I have, and, you know, in ways that I think sort of just, you know, as my memory doesn't operate that well, and then we're asking this applicant to, you know, recount a very difficult, traumatic, sometimes very confusing story. So again, that's where I'd like to, you know, come up with timelines, come up to try to, you know, get as clear a picture of what happened as possible. Because there are occasions where an officer, it feels a little bit like gotcha. It's like, you know, well, wait a minute, I thought you said that happened on a Wednesday. Now it sounds like you're saying, you know, it was Friday prayers, you know, or something like that. Inconsistency, you know, adverse credibility determination, I'm going to refer you to the immigration judge. So again, that's part of your job is to, you know, clarify with the applicant, with your client, you know, what dates are they sure about and what dates are they not, and make sure that they understand that if they're not sure, they should, you know, not be falsely specific, because I think that's what the officer wants to hear. And so, you know, figure out what you know, figure out what your, you know, known unknowns are. Not to sound too much like Donald Rumsfeld. The man wasn't wrong when he was talking about that. And you know, and sometimes, and also it means that, you know, rigorously checking, like, you know, the breadth of your application. You know, if there's outside material that's maybe been prepared by someone else. I once got referred for a client who had some of the clearest, like, medical evidence of torture that I've ever come across. And I had a extremely detailed, you know, medical report from a very well qualified, you know, 30 years in the emergency room doctor, which I kind of felt had pretty much clinched it. And here, this was on me. This was, you know, a mistake I made because the medical report was just so strong in terms of what it documented. I wasn't as rigorous in checking, you know, the introductory notes he made. And in one of those notes, he said, you know, client reports he was arrested on this date or something like that. Well, that date actually did not comport with what was in the affidavit, and we got referred on that basis. So again, I think that's a pretty problematic decision on the officer's part. I respectfully disagree, and I feel very confident that, you know, we're going to win that one in front of the immigration judge. But it's an important practice point that, you know, you need to make sure that all of this stuff lines up. And maybe the client told something different to the doctor, and, you know, you call up the doctor and say, wait, did he say this, that, and the other? And if it's dramatically different, then you bring the client back in and say, wait a minute, if you said this to the doctor and you're saying this to me, what's going on? So again, the bottom line is that this is sort of a meticulous, very iterative process to try to get, you know, as firm a story as you can. Okay, I am probably taking too much time here. But I think we're covering a lot of good stuff. Other credibility stuff. So things you can FOIA, things you can, so we already talked about State Department and stuff. You're not going to be able to reach into that. Although, if you know that your client has applied for a visa previously, you know, try to get them to remember what they said to that officer. Many asylum applicants come into the United States on visas. In many cases, they may have lied to the consular officer in order to get that visa. That is understandable if you are fleeing for your life, right? That's not automatically going to sink your application, but you need to be, I think it behooves you to be very clear about that, you know, sort of, you know, right up front, you know, as when you're in the interview. Is some clients want to try to kind of pretend that they were, you know, fully truthful with the consular officer. You know, they're desperately trying to flee. Chances are they made an exaggeration, they fibbed, they probably failed to disclose an arrest, right? That is one of the questions that every consular officer is going to ask as part of a visa process. Have you ever been arrested? Well, they may have been arrested because they're being persecuted, right? But they will have told the consular officer no. So again, that's not going to sink you. You just need to be, you know, very forthcoming about that. And that can be hard, trying to get your, you know, client to, you know, think back and remember what was said, you know, in that consular interview, which probably happened 4 or 5 years ago, right? I don't know if we said before, you lodge an affirmative asylum application, you know, with a 589. Right now at Newark, we're 2.5, 3 year wait. It's a very backed up system. So it's under the reg, it's supposed to take 6 months, but that's just not the reality. Yeah, and I think things we've covered before, like know your client's story inside and out, cross-examination. So this obviously happens. So when you're, again, procedurally, when you're in the asylum officer, it's the officer, it's you, it's the client. Once you get to, if you get referred to the immigration court, it, becomes essentially an adversarial process. So, you're on one side, and there's an ICE attorney on the other side who's going to cross-examine your client. Technically you could cross-examine, but I've never seen an ICE attorney ever produce a witness. So I've never had the opportunity to cross-examine anybody.
I think, Joe, this is more in terms of client preparation. So this is what one of the things I say to my students in the clinic, because they're always nervous about the idea of challenging what the client is saying to you, right?
Mm-hmm.
If you come across information that suggests that it's not consistent with the conditions information, you need to cross-examine your own clients, right? Because what you're doing is actually preparing them for when they go in front of whoever the adjudicator is going to be, whether it's an asylum officer or the judge, right? So obviously you need to do it in a way that you would allow the client to understand that you're doing this because you want to make sure that there are no holes in the story. But you should be cross-examining and challenging information that doesn't seem right to you. Because if it doesn't seem right to you, you're not going to be able to present this story on behalf of the client to whoever the adjudicator is, and then you're also giving the client open because there are weaknesses in the case that he or she has never had to deal with before, so that when they go to the officer, they have no responses to it.
Yeah. And that is absolutely correct. And this is also can be really hard. I mean, this is the part of our job that like the social workers in our office, hate. Because again, if you have a client who's suffered traumatic experiences, the hard fact of our jobs is we're going to have to get them to tell that story repeatedly, over and over again. And partly we're clarifying that story for purposes of presenting the best case, but we're also preparing them because they have to tell that story, to an AO or to an IJ in order to get that grant. That's part of their jobs. They've got to, find it within themselves, and part of that is just practice, is just getting it out there multiple times. And it can be really difficult, if you're bringing up this horrible thing for the 10th time and they're crying for the 10th time, it's not an easy thing to do. Okay, procedure. So tabs D and L in our binder. Let me grab mine. So basically, we D-L were sort of included the sort of the constellation of forms. And actually, Io, and let me ask a quick kind of timing question. How are we doing? Should I quick time this or?
Yeah, I think we're going
to go right to the break.
Well, we're going to play two now.
Four people. Well, why don't we actually go ahead and take a break? I think it's right in the middle, so this is a clear enough breaking point. Thanks, folks. Yeah, how about 10? Let's keep it to 10. Yeah. Yeah, no, I'll definitely make sure that. Ready?
Okay, guys, so I think we're going to try to get this going again soon. So if you could find your seats.
Not yet, I'm just restart order.
Okay, for the remainder of this section, we're just going to do I'm going to finish up with sort of a overview of the procedure, the process, and the forms.
Maybe the first thing that's in your binders I would draw your attention to is tab C, which,
well, really that just exemplifies why we're not actually going to talk about all of the procedure. It's a real thicket, all the different sort of paths through which these applications can wind their ways. But very generally speaking, probably most of the applications that you might come across sort of at the early stages of this practice is a affirmative asylum application, someone who comes into the country on a visa. They are admitted under immigration law into the United States for a particular set of time. I'm always going to talk about the one-year deadline in a little bit, but basically they have to get that application submitted to the asylum office after that, within 1 year of their arrival.
the form that they use is the I-589, application for asylum and withholding of removal, This form will actually cover several forms of protection. So
asylum status, kind of the gold standard, is the first thing you're usually asking for. Without going too much into the nitty-gritties, you can also ask for protection under the Convention Against Torture. There's like a little box right at the top that you check for that one. And also that form sort of sets clients up for two sort of lesser forms of protection called withholding of removal, and then there's even something called CAT, deferral of removal, but that in particular is sort of beyond the scope, I think, of today's conversation. The 589 form is, it's mostly pretty straightforward. CIS also publishes companion instructions with these forms, and take these binders home. These are a fantastic resource. I know IO has worked very hard over the years putting all this stuff together, and there's a lot of really great explanation in here. It starts out with kind of biographic information, tell us about yourself, tell us about your family members. It then transitions into a series of, kind of short answer questions, for lack of a better term. First there's like a, usually, I guess there's a check box. Have you, your family, friends, or colleagues, I'm on page 5 of the application here, ever experienced harm or mistreatment? So this page, these next couple of pages is kind of where the actual application is made. So first, we were talking about the various grounds. You've got check boxes for all of those: race, religion, nationality, political opinion, social group, and then also the Convention Against Torture. And it's literally just sort of tick the boxes. And then you can kind of go through these questions. Now, as a kind of a practice matter here, this is kind of a broad and universal form. This is also something that's used by pro se applicants. I kind of think of this form, it's a little bit like the habeas corpus form that a prisoner might fill out. So it's a form that's relatively easy for someone who's not an attorney, say relatively, to sort of access, figure out, understand, and use if they're on their own. However, when I'm preparing the habeas corpus petition, I do not use the form that the district court provides. I, write a petition that, discusses all the matters of law. And I think in sort of a similar way, if I'm representing an asylum applicant, and I don't know, maybe, I don't know, Io, if your practice is a little different on this, I will tend to give very short, kind of 1 or 2 sentence answers to each of these questions. Because again, and then I'll usually refer the officer over to the affidavit. So I want that affidavit to be the, kind of the full recounting of the story. I want the focus to be on that affidavit. So I think that's just sort of a more helpful format. And then in many cases, not all, I'm also going to submit a sort of, very brief of law, just kind of describing, why this person should get, should get asylum. And when I say a brief, I mean, these asylum officers have been trained in this stuff, right? You don't have to start off with an explanatory paragraph like you might on a general civil litigation case in front of a district court judge, like, this is the statute and these are the regulatory authorities, et cetera, et cetera, et cetera. You can go right in and start using, technical terms, well-founded fear, this is the enumerated grounds on which they should get asylum. So those are sort of the, the components of an application. And then you're also going to back it up with country conditions material. So then you just produce this packet of documents. There's a signature page where your applicant is going to sign, it's page 9. You staple their photographs to it. These applications, and I know the address is in here, they're also available on the CIS website, get sent to the Vermont Service Center for our part of the country. You do a copy of the complete application for the principal applicant. You do a copy of the application for each derivative, so spouses, children, and then you do 2 extra copies. If you're doing the full application off to Vermont, that can be a formidable amount of paper. For various reasons, again, this is my practice, is usually what I'll send to Vermont is the 589, and, the copy of the passport, sort of the, and again, these lists are in here, so you can look this stuff up. Kind of the bare minimum to have sort of a facially complete application, because then I know that that application packet is going to get sent from Vermont to Newark. You've got a 3-year wait, your country conditions are going to change, and the rule at Newark is 1 week up to 1 week before the actual interview, you can supplement your application. So, given the amount of time we're waiting, so it means you don't let this stuff slip on you. You have to have this material ready to go. But I like to send it directly to the asylum office in a supplemental submission, preferably about a week and a half before. And you really do want to make sure it gets there a week before, because they need time to, take that packet of paper from the mailroom and then link it back up to the proper file. If it's within that week and they don't make that link and you show up for the interview, the officer might open up the file that morning and there's no affidavit in it and they're just not going to be ready to go. And, that's no fun. I mean, they're probably going to reschedule you, but that can, delay your client's case even longer. So that's the basic affirmative process and sort of some of the documentary requirements. So I've already sort of described how the actual interview at the asylum office works. A few other sort of technical things just in the next couple of tabs. At tab E, we have a G28. This is the form you use to enter your appearance in front of USCIS. And, well, often in front of ICE or CBP, but, you're using it for CIS in this case. So this is just the administrative entry of appearance form. I think that's quite straightforward. Well, maybe the one thing I would sort of point out is that whenever you're filling these out, is to pay attention on page 3. There's 2 check boxes having to do with where you want documents sent. This is usually most relevant when you apply for a client's work authorization card, which is obviously something that is extremely important and valuable to them. So be very clear, do you want the, most clients, by default is, we're going to have this sent to our office because we know this is a safe place where it can be received and you can come pick it up. But some clients are going to want it sent, to their home, and that's just a conversation. Make sure they have a, link so they can safely recover that stuff. At tab F, the Heartland Alliance is an excellent nonprofit out of Chicago. We just had a full sort of checklist of the basic forms that they're going to include in your application. H is a certificate of translation. Probably doesn't need to be said, but if you have a lot of documents in a foreign language, you need to provide a English language translation, and you need to include a little certificate by whoever did that translation, where they certify that they're competent to do this work, and that they've translated the document to the best of their ability. So there's the sample certificate of translation. At the actual interview, if your applicant does not speak English, they will need to bring an interpreter to do the interpretation, live interpretation. You want someone who is, at the least, familiar with doing sort of live in-person interpretation, because if the interpreter starts telling the story, that's an enormous problem. And, that's usually going to be extraordinarily obvious. In fact, it's going to be obvious because the practice at Newark is they're going to get a monitor on the telephone. And maybe Susan could explain to us why the monitor just doesn't directly do the interpretation. I've actually never understood that. But they're going to get a monitor on the phone who's going to monitor the interpretation of the interpreter you bring with you to make sure that everything is copacetic. So, the worst case scenario is, there are cases where, you might have a friend or who's doing the interpretation, and they start trying to advocate for the applicant. Like, that is absolutely a no-no. They need to, word for word interpret what comes out of the officer's mouth and what comes out of the applicant's mouth, and be sort of, as invisible as possible in that whole process. We have another form that is pretty important, the AR11 at tab J. This is the form that you use to update your address with USCIS. So what my practice actually, I don't know, Susan, chime in if you don't think this makes sense. So there's an address on an AR11 that's sort of the USCIS centralized address. So I always send a copy off to the centralized address, and then I will do a separate copy and send it directly to the asylum office. Just because I find that, yeah, good, thumbs up. That just really facilitates everybody being on the same page as where your client is. Yeah, and you can do it electronically too, right? And it is also the law. People who are applying for asylum, they have, I think it's 10 days maybe to update an address or something like that. But as soon as they move, you need to, get that address updated. Finally, at K, we have an example of a receipt notice. So, somewhere, I guess in Newark, they must have some massive industrial dot matrix printer that produces these slips that get mailed off to everybody, and that is the evidence that they have lodged their application. And this is a pretty important piece of paper, especially when your person is first come. If they're here and they've overstayed a visa, that is their best evidence that they are trying to do something about their status. So if, for example, they have a run-in with ICE, with the immigration police, that's a pretty important piece of paper, especially when they're within the window before they've been able to apply for their employment authorization card. So the basic rule is once you get that form, it's going to have a date, a receipt date. So, it's pending as of, in this example, 7/28/2003. 6 months from that date, you can apply for an employment authorization card, which both gives them the legal ability to work in the United States, which is a pretty critical thing, but it also is, government-issued photo ID that is sort of, indicative that they are not accruing unlawful presence, that, they are in the process of normalizing status. Again, just to sort of finish up the quick sort of procedural basics, and we've touched on some of this before. So you have your asylum interview. In most cases, the typical case, the officer can do two things. They can grant asylum, or they can refer. You're never going to get a decision the day of, because what happens is the interview happens, then the officer is going to take the interview, all the backcountry conditions, they may draw upon, whatever information they sort of have internally, and, put all that together. And, there's an internal process that, maybe Susan can talk more about in terms of, how that decision gets made. But typically, the applicant has to show up in person 2 weeks later and pick up their decision. In some cases, they'll refer it to a mail-out decision, usually if there's going to be extra background checks, in which case it could be a much longer wait. I have some clients waiting 6-7 months to get their decisions. Again, two options. They can grant asylum, which is, of course, what the goal is, in which case they then have asylee status. They can apply for a green card after a year. And asylee status in and of itself is a permanent immigration status that confers, the permanent right to work in the United States. So obviously they should get that green card when they can. Or they will be referred. And that just means that you're then getting sent on for de novo review in front of an immigration judge. So your file is sort of being passed off from the Department of Homeland Security, from the Asylum Office, to the Executive Office of Immigration Review in the Department of Justice and the immigration courts. As we said before, from the immigration judge, you can go to the Board of Immigration Appeals, and then from there to the circuit courts, and once in the blue moon, something will go up to the Supreme Court, but that is rare. Okay, so that is, I think, a very quick procedural overview. I'm just going to speak very briefly on the credible fear interview process, because I think we're getting a little bit behind here. This is a process, this is sort of like a truncated asylum interview, also performed by asylum officers. They sort of get seconded to various parts of the country or sent out on detail, which is, I think, partly why our waiting is so long, because officers like in Newark or in Chicago or the various asylum offices were being sent off to the Texas-Mexico border to do credible fear interviews down there. But it's basically a truncated process for arriving aliens who show up at the border and express a fear of return. So usually they're going to be detained. They're going to get this, credible fear interview that, is very much, it's an asylum interview sort of in mini. And the officer is going to assess if there's a significant possibility of asylum eligibility. And then if the finding is positive, they'll be referred on, they'll be NTA'd and sent on to an immigration judge. If there is a denial at the credible fear process, there is a review before an immigration judge. And then, if the judge agrees, then the case can proceed from there. There's also a reasonable fear process, which is a different, a higher standard of belief, standard of review, and there's different forms of relief available. Again, I think I'm going to sort of brush past this part because for most of the clients we're talking about, we're past this stage. And then 1 year deadline, I think that's that yellow or that meeting. Yeah. Okay, I'm done then. Thank you very much. Oh yeah, sure, go ahead. Mm-hmm.
Given the wait time of the processing or consultation of given any ability to supplement, how much do you recommend getting done before actually the final application? Do you need a full case history, a full legal analysis, and then trying to get it off?
Yeah, no, that's an excellent question, because these things can kind of be in tension, right? Like taking, the time to fully document everything versus getting that clock going. And what I do personally is I am kind of splitting the difference. So I'm going to get as far down, I'm going to get as far into that affidavit process and sort of that figuring out the story process that, I am satisfied that there is a, that there is a colorable claim, that I believe this person's story, that I don't think there's any fraud issues, and then I'm going to proceed from there. And then I can continue to develop, especially the country conditions stuff, because the big thing is like over a 3-year wait, country conditions change. So it's, it's worth kind of keeping tabs on what goes on in the intervening years. And sometimes you want to get that on the record. Sometimes it's not particularly relevant, like what's happened, in year 2, year 3. But, so then it's just a process of keeping tabs on it. But yeah, in particular, so like, at nonprofits such as ours, the people we're dealing with are poor. And that lack of a EAD card is a towering concern in their lives because, some of them, they'll probably have a little bit of a, nest egg from when they came in, but that can go very quickly. And then they can just be in, really dire straits, and getting that work card is a critical part. So, I can't give like a perfectly definitive answer, but yeah, so you need to be sure that the claim is valid, the claim is colorable, that you don't have any, obvious fraud concerns. But then, yeah, then I do submit the 589.
That. I mean, I think it is important for you to be clear that your client has a viable claim, because if you file the application and it gets denied, you are then getting them referred to an immigration judge who will decide whether they get to stay in the United States or not. Whereas you can make a determination that this is not a viable application, you can tell the client that, and then he or she then gets to decide what they want to do as a result. But once that application is gone, you've exposed them, you've said to the government, this person is here, most likely undocumented, because, unless they've been able to switch into different immigration categories, which can be difficult because most applications, you're being asked to make a statement that you will leave after the time that you have been given to stay in the United States. But if you're claiming asylum, you're asking to be here permanently, so there's a conflict there, right? And I will say that there are some types of cases where if it is an FGM, then we've got the examination that confirms that FGM has occurred. I'm writing a skeletal I-589. I'm filing it with the medical information, and at least the clock is starting. And I know we keep talking about the clock, and you're probably wondering, what clock are you talking about? We'll get to that in a minute, because that relates to the employment authorization and just when you're able to actually file an application for work authorization. Yes.
I can jump in real quick. There is a penalty here. It's possible for someone to find a frivolous asylum application. Frivolous really means fraudulent. But if there's a finding down the line that an application is fraudulent, I mean, it basically that can end all other immigration remedies, and set the client up for perjury prosecution. So that's the threat over there.
Well, I mean, the one good thing, not that we encourage this, but the one good thing is that the frivolous application finding can only be made by a judge after a warning has been given. So even if this person makes the frivolous application in front of the asylum office, right, and you figure out that this is a frivolous application, I mean, it would behove you to tell them to withdraw that application. Of course, it goes back to Richard's claim, which is, well, how do you get consistent with other applications that have been filed? And this causes a major problem in terms of credibility in front of the immigration judge. But at least if that person has withdrawn that frivolous application, at least there's the potential for relief in the future if ever they qualify, right? Okay, the one-year deadline. So the law requires anyone who is filing an application for asylum to file within 1 year of entry into the United States. That does happen. More often than not, it doesn't happen for a number of different reasons. Maybe the person didn't know that they could file for asylum, right? Didn't even know that that relief was available. Perhaps they came in a particular category, maybe as a student or a visitor, and at the time that they came into the United States, there wasn't a basis for asylum for them to file an application, right? So you're required to file within 1 year, but there is an exception if you don't manage to file within that 1 year time period. You can file outside of the 1 year deadline so long as, and still be eligible for asylum relief so long as you can show that one of the exceptions applies to you. Two exceptions, that there is changed circumstances in your country which now makes it possible for you to file asylum, or now makes it a danger for you to return home, or there were extraordinary circumstances which prevented you from filing within the 1 year deadline. But even within the extraordinary circumstances, this requires an examination of the facts, and you're still required to file an application within a reasonable time after that you become aware of the need to file asylum, right? So, and typically we sort of go by this whole idea of within 6 months of whatever the disability was, you need to file the asylum application. That's generally what it looks like. But even if you're outside of that time frame, it may be possible for you to explain it. So I had a case many years ago of a woman from Liberia during the time of the Civil War, and the facts of her case were really horrendous. I mean, it was just awful, awful, awful. And so she was so traumatized, she could not discuss what had happened. So even when she finally came in to see me, I'd make an appointment for her, she wouldn't come back. She wouldn't come back for a year. So we were able to get medical documentation that showed that this person was suffering from such severe mental health issues that 5, 6 years after she had come into the United States, she was still under the disability and so therefore couldn't file. My colleague Judy pushed it even further, and she got asylum for a Chinese guy who'd been in the United States for nearly 30 years, which is like, what? But anyway, I mean, so this is what we do. We just keep pushing the envelope. Carol.
So, what is the when is the 1 year measure? So, somebody has gets a tourist visa. They come here to visit family or for some conference or whatever. They go back, then they come back again, and they're maybe on their third visit, and something has happened in Israel.
Right, so it's the last entry into the United States. The last entry. No, but the scenario you give raises other issues, right? So, I mean, you said that something happened in the interim, right? And so the question becomes, well, when was that interim? Was that so essentially what you're looking at was, what was the catalyst that brought this person to the United States so that they could claim asylum, right? If you have somebody who's, let's say they're a political opponent of the government, right, and they've been active in this, they've been active within the politics of the country for a number of years, and they come to the United States, come for a short visit, they go back, there's all this back and forth. Even if they file their application within the 1 year deadline, right, as in 1 year from the last entry, the question becomes, well, why didn't you apply the first time that you came, right? Because the factors that gave rise to an asylum claim may have existed already at that point. So that then raises issues in terms of credibility, okay? But, you know, you will learn as you deal with these cases that a lot of people, I can only speak for myself, but a lot of people are way braver than I am. And they are, you know, what I would call freedom fighters, right? And so even though they may have experienced harm and torture in their country and they've left and gone back, it's because they really do believe in whatever their political views are and they want to continue to fight for whatever it is that they're trying to seek in their country. And so it's important to be able to listen to this person to understand why didn't you apply beforehand, and then you make that argument, right? And so then it becomes a question of whether or not the adjudicator is going to accept it, given this particular person's background. Okay? So the 1 year deadline, as we discussed, this case, matter of MAS, we use initials a lot just because we don't want to necessarily want to identify the applicant. This is a case where the Board of Immigration Appeals was looking at the issue of the 1 year deadline. And when does the 1 year deadline actually apply? So it goes to Carol's question, right? It's supposed to be 1 year from the date that you arrived and you last arrived in the United States. But matter of MAS says, if you filed an application for asylum and it was post the Real ID Act, May 11th, 2005, right? And then you file a subsequent application. And that subsequent application is substantially different from the first application that you filed. An immigration judge can determine that the date of filing that substantially different application is the date from which you then start to calculate your 1 year deadline. So you may actually be outside of the 1 year because of this subsequent application. So as a nonprofit, we often get cases that have started somewhere else, right? And perhaps the person that initially dealt with the application missed a significant part of the applicant's claim. And so how do you then present this additional information without triggering this whole idea of a substantially different application so that the client doesn't lose the 1 year deadline? Because that's important. So you need to think it through, and it may require some creative lawyering, and it may be that, you know, the last person who filed just totally screwed it up and there's nothing you can do. You have to just be clear and say, yeah, this is a different application. But you'll have to, you know, really look at the facts. Just giving you more information. Bars to asylum eligibility, right? If you have persecuted others, right, if you're a persecutor yourself, then you are barred from claiming asylum. And I'm very clear on this point, and I've won at the BIA. The persecution that your client has engaged in has to be for one of the 5 grounds. If it's for another reason, doesn't matter. Okay? Hopefully you're not dealing with persecutors of others, but, you know, we want to try to defend. Anyway, so persecutors for one of the 5 grounds. Firmly resettled. So that means that somebody who has actually been living in a country outside of their country of nationality. But you need to be careful about this whole idea of firm resettlement. Just because somebody's been living in a country for 10 years doesn't mean that they are firmly resettled, right? You've got to look at the facts, okay? Look at how they have been living in this other country. Were they on a pathway to the equivalent of citizenship in that country? Were they given the freedom to work, to study, to travel in and out of the country? We can look at Saudi Arabia as a perfect example. Guest workers in Saudi Arabia are not allowed to, well, their children can study up until 18, and then after that, you basically do nothing because you're not allowed to work, you're not allowed to continue studying, right? Your rights within Saudi Arabia are substantially less than Saudi Arabians. So there's a whole argument that somebody who's been living in Saudi Arabia may not be firmly resettled, okay? And if you're being persecuted in this third country, well then, is that firm resettlement? So it's really important to do an investigation of the facts to make a determination as to whether or not you can argue against the idea of firm resettlement. Previous asylum application, if you filed for asylum before, you're not supposed to be able to file another application. I take issue with that, of course I do, because you know me. And I take the view that if you are filing an application because there are changed circumstances, and you can document that, it may be possible for you to file an application for asylum. If you've already been deported and you somehow come back, that raises other questions as well, and we'll deal with that too. But I don't, just because it says because you filed a previous asylum application you shouldn't be eligible, I think that that's arguable, right? The one-year deadline issue. If you file your application more than 1 year and you can't meet one of the exceptions to the one-year deadline, then you're barred from asylum. That doesn't bar you from other humanitarian forms of relief, but the benefits that you get as a result are substantially reduced in comparison to an asylum grant. Aggravated felons. This is a specific definition for immigration purposes. Look at the statutory provisions, 101A43. So it gives you a whole list of different people who are considered to be aggravated felons. It has nothing to do, I mean, it does have something to do with the criminal law, but the definition can include crimes that you would not believe should be considered or should categorize somebody as an aggravated felon. So it is important to do that review. Someone
Doesn't have to be a felony, for example.
Exactly. Yeah, it doesn't. Someone who's considered to be a threat to the U.S., they would be barred from asylum eligibility. And it's really interesting, those cases, because I think these are the ones where you have the secret evidence is presented, so you don't even know. You're not allowed to fully defend yourself because it's all secret evidence that the government presents and the judge gets to see, but you don't necessarily. So, I mean, yeah, there's due process there, but I mean, that's another issue altogether. And then there's safe third country removal. If you're coming in from a country where there is a safe third country agreement, such as Canada, if you arrived in Canada first and then came to the United States can return you back to Canada and vice versa, so that you can process for a claim for asylum in that other country first. Yes?
To make the point that the U.S. actually resettles refugees from those camps and from that country. So it sort of supports the idea that the person was not firmly resettled there.
Well, I mean, if you're in a refugee camp, to start off with, I would say that you're not firmly resettled just because of the living conditions, right? I mean, many people in the camp are required to live on the camp. They're not allowed outside into the general public. So I would say just being in the camp on its own is, you know, raises issues in terms of family settlement. Susan, I saw your hand. Right. Material support to terrorist activity, to terrorist organization, another nebulous category as far as I'm concerned. These cases can sort of languish at headquarters for years before there's a decision, and then it also presents difficulties in terms of the next step. Once you get asylum and adjustment, it can delay you. Do you have your hand up? Sorry. So Yeah, so if you look at the case that I have at the bottom, this Third Circuit case, even if you were if you were under duress to engage in activity that could be considered persecutory, it doesn't, what's the word I want? It doesn't absolve you.
The rules are very, very harsh.
Yes, I mean, even if you look at this thing called Third Circuit case, you know, one of the judges was sort of pointing out the irony that even if you provide somebody a glass of water, that could be considered material support, right? But and the fact that you are doing it because you're trying to make a choice between, do I just give him this glass of water or do I just let him shoot me in the head, right? But that's the state of the law that we have right now.
Or I mean, even more harshly, I think the argument would be made that if you were a baby sex slave of ISIS, when you weren't being serially raped, you're made to cook and clean. That's material support of the terrorist organization. So this fact pattern has not been tested, but I think that the argument that comes out of Singapore and Keepsake would apply to that scenario as well. So yeah, these rules are nuts, in my opinion.
I don't disagree, but you know, nobody asked me when they were writing it. So yes, I mean, you sort of see the just how difficult some areas of the immigration law can be with respect to those who are claiming asylum and have basically had to do whatever they needed to do in order to preserve their own lives, right? It is very difficult. The employment authorization clock. So Jonah has referred to this, and as he said, this is absolutely important for your clients. Asylum applicants are not allowed to work or to get permission to work in the United States for the first 6 months that they're in the United States. They have to wait 150 days before they can apply for permission to work. As soon as the Immigration Service gets the application, they receive it, right? They're going to give it a date, a receipt date. And the clock will begin to run then. That's what we mean by the clock, counting the number of days that you're having to wait before you qualify to apply for asylum. The 150 days is not a strict 150 days. If the applicant does anything that delays the processing of his or her case, the clock stops running. And it will not start running again until they do whatever it was that they were supposed to have done. So the first thing that's going to happen once the Immigration Service gets this application, they'll send you the receipt notice. Within a couple of days, you're going to get a notice for the client that they need to go and do biometrics. Anyone who is seeking a form of immigration relief has to do biometrics. That's when you go to an application support center and you have your, excuse me, you have your fingerprints and your picture taken, captured digitally. If the applicant doesn't go when they are supposed to go, the clock stops running, right? And it won't start again until you are, until you appear. Anything else probably doesn't matter because, as Susan says, it's taken the asylum office 3 years, nearly 3 years before you come in for an interview. You will have met your 150 days, so you'll be fine, right? Once you hit 150 days, you can then file your application for work authorization. And the form you'll see is at tab, excuse me, it's at tab N. Pretty straightforward. The only thing that's not so straightforward, although you have the directions there, is the category that you need to place in section 20, question 20. So it's asking you, under what category does your client qualify for work authorization. You've got to tell them, right? And in this particular case, it's C8 for asylees, people who are seeking work authorization while they're waiting for their asylum application to be approved. What is now happening, so in the past what was happening is that employment authorization cards, or EAD cards, were being issued for 1 year. They're now being issued for 2 years, right? But if your client gets to the point where they need to apply to renew their EAD card, right, so this is also a change, they need to renew their EAD card, you need to file that renewal before the current card expires. And if the Immigration Service receives that application before the current card expires, and you are filing in exactly the same category, the C8 category, the current card automatically gets extended for 6 months. The regulations say that the Immigration Service is supposed to process an application to renew work authorization within 90 days. They don't. And so their way of trying to sort of remedy that was to introduce this idea of the automatic extension. Just came in January. Okay? So it's important that you file the application, get it reseated before the current time frame ends, and then your client will automatically get an extension. Okay? If you file in a different category, then they're in the general pool and they just have to wait until they get their card. Okay? So the benefits of the grant of asylum. Once a person gets granted asylum, they are in that category indefinitely, unless the Immigration Service, unless they do something which places them into removal proceedings, or unless this application for asylum is determined to have been fraudulent, right? So, unfortunately, there are people who are willing to file what I would say pro forma applications. So I've had a case of a gentleman who was actually a Chinese Christian from Indonesia, and the asylum office called him in and said, you know, we want you to come in because we believe your application for asylum is fraudulent, and we are basing this on the fact that we arrested the attorney who filed your application, and that attorney is telling us that your application is fraudulent. So you come in and you demonstrate to us that this was not a fraudulent application. Fortunately, in terms of this client's case, because how do you go about demonstrating that anyway, for many years later? But in his particular case, the Immigration Service sat on his interview. They didn't call him in for years, and so there is a statute of limitations. If they don't do anything within 5 years, then they can't do anything beyond that. And so that's what happened in this particular case. Although they got him at the citizenship stage, so he wasn't able to become a citizen because he couldn't provide evidence to show that this was not a fraudulent application. You get granted asylum for an indefinite period. After 1 year of being in asylum status, you can apply for lawful permanent residency. That's the green card that everybody talks about, okay? And once you get your green card, the green card is backdated for 1 year. A little bit different for refugees. Those who enter the United States as refugees, when they apply for their green card gets backdated to the date that they entered. So they lose no time whatsoever. So even though an asylee's green card will be backdated for 1 year, they actually lose considerably more time, right? Because it's only 1 year from the period that they were granted asylum, so they've lost all the time that it took for them to get asylum, which is a number of years. And then you've also lose the time that it takes while you're applying and they process your application and you get granted. So you only get a credit of 1 year. But at least once you get your green card, you're on a pathway to citizenship, okay? Most people who, well, I shouldn't say most people, but to get citizenship, you can do it by 2 ways. If you're married to a U.S. citizen, then you have to have your green card for 3 years. And if you're not married to a U.S. citizen, you have to wait 5 years. okay? As an asylee, you are able to be reunited with your family. So it's any family that existed at the time of your grant. Not any family, but specific family members that existed at the time of the grant. The family members that you can include are spouses and also children who were under 21 at the time that you filed your application. So even if 3 years later they're 22, 23, it doesn't matter because they were under 21 at the time that you filed your application. Yes? Well, it doesn't. No, that's not the criteria that determines whether or not you can bring the family member in. It does create problems if you didn't put the family member on the I-589 because it asks you what family members do you have, right? So if you don't include them, then it raises up the whole questions as to whether or not they are actually family members. But in most embassies, they make you do DNA tests for children anyway, so I wouldn't say that you lose that much by doing that. Okay, thank you.
Okay, Michael? Yeah. Okay, I'm going to talk quickly about withholding of removal. When discussing this topic, I like to jump back to the Refugee Convention itself. So the structure of the convention is it opens up with Article 1, the refugee definition, well-founded fear of persecution on one of 5 enumerated grounds, the definition we've been picking apart for the last several hours. Thank you very much. Then there are a series of articles that talk about essentially refugee rights, like how is a country supposed to treat a refugee, what benefits under their immigration code are they supposed to give refugees, and basically all of those rights are essentially non-binding. They're sort of guidelines. There's a lot of should language. At the end of the convention, though, there is an article with teeth, and it's called the non-refoulement obligation. The convention was mostly negotiated in French. It's just the French word for non-return. And it basically says that refugees can't be returned to a country where their life or freedom, where their human rights would be significantly violated, because of who they are, because they meet the refugee definition. The way that all plays out in our legal code is, we have this separate sort of category of protection that directly maps on to the U.S. government's non-refoulement obligation under international law. So an asylum application, one must meet the refugee definition. However, it's not mandatory. There is a discretionary aspect in there. An adjudicator can decide that the applicant in front of them meets the definition of a refugee and still deny asylum status on discretionary grounds. Which actually, that does add to another component of these applications that, if you have an applicant who maybe has a shoplifting arrest or something, something that's not serious enough that's going to trigger inadmissibility or portability grounds that are more complicated, but still makes them look bad, you might need to put some sort of resuscitating sort of evidence in that application so that you're sort of ticking that discretionary ground box. And this also will become particularly important in front of the immigration judge, right? If there's sort of discretionary issues, these cases are going to get referred up, and then you're going to need to show the judge that your client's a good person. That being said, withholding of removal is mandatory. We signed 67 Protocol. We are bound, to this provision under international law. There are a number of ways in which people can sort of, land in sort of withholding sort of territory, as, listed here. If they apply outside the 1-year deadline, that's probably the biggest one that catches up a lot of people. You're no longer eligible for a discretionary grant of asylum if you apply outside that 1 year, and if you can't make one of the exceptions that I was talking about, or because of, various more, serious forms of criminal history. You're going to be in withholding of removal territory. The main distinction, and I sort of referred to these cases earlier, the sort of twin cases of Stevic and Cardozo-Fonseca, is that there is a higher evidentiary burden on people trying to make a withholding of removal case. Now, you know, people who sort of study this stuff and write about this stuff from an international law perspective, this drives them crazy because they think there's and I think they're right, there's no sort of coherent ground in the convention under international law for there to be this like evidentiary bifurcation. However, that is what the Supreme Court has done in the United States. So it means that you know, you're no longer, you know, having to meet that, you know, sort of the well-founded fear standard. You're having to meet a higher standard of more likely than not, and that's articulated in the Supreme Court case of INS v. Stevick. Cardozo-Fonseca is the one that discusses the evidentiary burdens under an asylum application. And the other difference, and sort of the big difference, is that withholding is, you know, not as good a status. It is permanent, well, permanent until it is taken away, of course, but it, you know, does not lead to a green card. That's sort of the, I think, the most kind of functional difference, is that it's not going to put that person on a path towards, you know, legal permanent residence and towards then getting U.S. citizenship and really sort of stabilizing their life here. So they're not going to be able to, you know, later, you know, file for family members and all of these types of things. So it can make a very big difference for some applicants. Yeah, so I think basically I've said all of these 3 points here. It's a limited form of relief, and although, you know, it never goes away, you know, if you have someone who's been here for a long time, you can't make that one-year deadline argument. You know, you can fall back, you might be able to fall back on withholding. And the other, you know, real heartbreaker for this is, you know, no family resettlement. They're not going to be able to bring in, you know, other family members as a, you know, someone under withholding, you know. They might, it just doesn't necessarily preclude them from seeking other remedies under immigration law through family petition, I guess possibly labor petition, but, you know, they're not going to get anywhere past withholding just as someone who has received withholding. It is kind of a dead-end status. Yeah, sure, go ahead. Sorry, I didn't see you there. You're like right behind my camera. Yes, no, they do have the right to work, but they're going to need to continue to. The other sort of inconvenient thing is they've got to continue to, you know, renew these employment authorization cards. And also it can be, I mean, there's other sort of like softer disadvantages. You know, most people know what a green card is and understand what a legal permanent resident is. You know, it's harder to explain to like an employer or to someone at the DMV when you're trying to get your driver's license, you know, how withholding of removal works. You know, it is not a great status for people to try to cruise, you know, to build their new lives here in the United States under. You know, it can be a lot better than going back to a country where you're going to be at risk of, you know, severe mistreatment, but it is limited. Yeah, or that, yeah, certainly better, yeah, exactly. So yeah, that was a really short one. Convention Against Torture. Ailey, you want to come back up?
Okay, so as Jonah said, there are other forms of relief that are available if you're not just looking at asylum, right? Asylum discretionary, withholding of removal, mandatory, protection under the Convention Against Torture, that's also mandatory if you meet the criteria. And that would apply to those, typically applying to those who we looked at in terms of the bars to asylum eligibility. So if they're not eligible for asylum, they may be eligible for protection under the Convention Against Torture. The Convention, CAT, does require government involvement, right? And the definition of torture that you see here, as we have it from the Third Circuit, the guidance that they've given us, to me it seems fairly strict, not very fairly narrow. Intentional infliction of pain or suffering to obtain information or to punish, instigated or at the acquiescence of a public official acting in an official capacity, right? So if you have a rogue officer, it may be difficult for you to establish a Convention Against Torture claim. So the problem in terms of the intentional infliction of pain or suffering, is that, so we had been using CAT for people who are being sent back to Haiti because of the conditions of the prisons in Haiti, which are just horrendous. And so we were arguing that because the conditions were so awful and the treatment of prisoners was so terrible, this was an infliction of pain or suffering. And so this case actually, Pierre, and I remember going to listen to the arguments en banc, was essentially, it was a Haitian case, one of these standard prison conditions, et cetera, and the Third Circuit basically said, no, you need more than just the prison conditions. You need to show that the government is intentionally inflicting pain and suffering. I mean, if they never do anything to improve the prisons, could you make an argument? But anyway, we were told that we couldn't, so it wasn't successful. Mandatory relief, everyone is eligible if they meet the criteria. You need the government or someone acting with government acquiescence to be the persecutor, if you like, although it doesn't require persecution. Enumerated grounds, the 5 grounds are totally irrelevant, right? Not totally irrelevant, but you don't have to establish that the pain and suffering that was suffered was because of one of the 5 grounds. Yes.
Government acquiescence here the same as unwilling or unable to control?
No. So the unwilling and unable is not the same. You actually need affirmative action by the government. So, and when we talk about the government, it's not just the government in the cabinet. I mean, so if you have a police officer, police officer activity, so long as it's not a rogue police officer, then you can say, well, that's government acquiescence, right? Because they are part of the government forces.
Can you give an example of how that might be used in Central American scenarios that we're having today?
I can't because I don't use Convention Against Torture in those cases. At least to my mind, I think it would be difficult to make a convention case, or maybe I'm just not being creative enough. Have you tried?
No, I mean, another way to put it is like, officers like acting under color of law. I mean, there needs to be some nexus to, agent of the state acting in official capacity. And so it's everything that the gangs are doing are, at least on paper, illegal. Definitely on paper, illegal. So it's hard to say that they're in any way acting under color of law. If you have now a corrupt police officer who might be doing the torture, maybe at the behest of a gang, like that's a different scenario. But you need some nexus to the official state action.
Well, isn't one of the things that you get from those countries that the official get from us and if you go tell if you go report a crime, they report it back to the gangs and then that gets you threatened with an act count, something like that?
I think you maybe will be getting into the sort of the zone where you might be able to start making that case, but I still think it's tough.
There hasn't been anything out there yet.
Not that I know of.
I think there would be a problem because, I think you don't just want a rogue officer, right? I think you want more of a systematic police involvement because typically when you just have the rogue officer, then you can say the government wasn't acquiescing in this, right? So I think you would need more of an entire department that being given direction from somebody higher up. And at least from what I'm seeing, that's not what's happening in Central America in terms of police involvement.
I mean, the purpose of the Convention Against Torture, which is sort of the legal underpinning of this, is directed at state action. The rules that are supposed to be binding on government.
Okay, so the standard of proof, more likely than not, that you are going to suffer torture. And then this BIA case, or the Attorney General case, matter of JSF, essentially says that if there are various steps that you need to establish in terms of demonstrating that there's a likelihood of torture, or it's more likely than torture, you have to show that each step in the chain meets that standard, that it's more likely than not that each step in the chain is going to occur. Okay. So in the Convention Against Torture claims, remember you're using the same form, the 589, right? The whole procedure is the same, but the type of relief that you're seeking may be different. So if you have a client who has the asylum application, but the judge says, you know what, I don't believe anything that you've said, not granting you asylum, no credibility, no asylum, no withholding, right? Even if you have those negative determinations against you in the asylum and withholding context, it doesn't matter in terms of the Convention Against Torture context if you can provide country conditions information that basically supports what the client is saying is likely to happen. Okay? That's the beta. Okay. Oh, there you go. Yeah.
Forward, I think we were actually on schedule, which is shocking.
Okay, so I am going to now just give a quick spiel for the quick pitch for the Philadelphia Partnership for Resilience, and which is a sort of initiative that can hopefully help some clients that you guys may help down the line. So PPR is a project that is administered through both NSC and HIAS primarily, are the two main partners. You know, there is a entire social service wing that's parked at NSC, and then we sort of split the legal responsibilities between HIAS and NSC. So, you know, IO takes some cases. I'm actually at about 40% PPR cases, and then there's another attorney at HIAS, Prachi, who does almost entirely PPR cases. And it's a very cool program because we can, you know, do all the legal work pro bono, but, you know, we're kind of used to doing a lot of pro bono cases regardless. The real value added, I think, is that, you know, clients can also get case management. They can get social work help, which, you know, we can't always provide all of our clients because that tends to be tied up with very particular funding sources. So yeah, the services include legal, social, medical, mental health, case management. Yeah, the money comes from the Office of Refugee Resettlement. So if you have a client who qualifies, it means that, you know, so obviously, I mean, I think in any case, IO or I or Prachi are going to be happy to, you know, provide advice, provide guidance in terms over the course of your representation. But then also we should be able to pair them up with a case manager who can help them, you know, sort of navigate, you know, all the difficult steps of, you know, recently arrived non-citizens, getting the driver's licenses, sometimes help finding work, help finding a place to live, all of this stuff. And the you know, and the sort of to qualify for the program is, I mean, so it's the Torture Victim Protection Act definition technically, but it's basically the definition we've just been talking about. You know, it's a requisite level of violence conducted under color of law, you know, by someone who has that nexus to, you know, state agency, state power. And that's a fairly quick, you know, assessment and determination that happens by the program coordinator who's based at MSC. And then once you're in, you're in. You know, it doesn't matter if you don't successfully finish that CAT claim at the end of it, and they can get all this social services help. And yeah, most of this client base is, you know, asylum seekers, refugees, asylees, although some of our older clients, you know, have their citizenship now, and we're working on, you know, bringing over family members from countries of origins many years down the line. Yeah, and so yeah, we basically will hang with these people throughout the life of their immigration case until they're citizens, until their derivatives are here. Although yeah, the majority of the casework is obviously affirmative asylum applications. Yeah, case management services, I think I already went through that. It's in your presentations. But yeah, it's a very cool program, and any of you who have clients you think may qualify, you know, please get in touch, and we will you know, try to get them signed up. Because if you haven't worked with this clientele before, especially if you have people who came, you know, without family members, it's hard to emphasize how profoundly kind of lonely and difficult that long wait can be between your arrival and, say, your asylum interview up in Newark, or until your case, makes its way through the immigration court. And with some clients, and as an attorney, you're not necessarily trained or necessarily have the predilection to sort of dealing with sort of distress and anxiety that can cause. So being able to refer, someone who is maybe in very delicate mental health to a social worker can really be a godsend. So that is the PPR program. I don't think I'm going to say much more about that. That also concludes sort of the meat of me and Io's presentation. And so now we have two esteemed guests. I see Judge Honeyman has just come in. Welcome. I think we're going to go to Susan first off. Let's take a 5-minute break. That's an excellent idea. So thank you, everyone, for your attention today. I know this has been a long slog through a lot of very complicated law, but we very much appreciate your attention. And stick around for our last two speakers, obviously.